Good morning, everyone. Welcome to our first day of our spring session oral argument here in the beautiful city of Philadelphia. I have some sad news. I'm very sorry to announce that we lost one of our great public servants last night. Judge Phyllis Beck passed away at the age of 97. Judge Beck was a proud Philadelphian, and she was the first woman to serve on our Pennsylvania Superior Court. She had graduated first in her class from Temple Law School. Judge Beck served on the Superior Court from 1981 to 2006, and her daughter, Alice Beck Dubois, now serves on that very same court, and to my knowledge, they're the only mother-daughter duo on an appellate court. We extend our sincere sympathy to Judge Alex Beck Dubois and to her family. As you may know, the Pennsylvania Supreme Court is the oldest appellate court in North America. Our roots date back to William Penn's Provincial Court of 1684, and we were formally established pursuant to the Pennsylvania Judiciary Act of 1722. In 2022, we celebrated the court's historic 300th anniversary here in Philadelphia, and we are privileged to sit in 3 historic courtrooms in Harrisburg, Pittsburgh, and Philadelphia. In its earliest years, the court actually convened in private residences, while the lower courts met in ale houses. I'm not sure what you can take away from that, but in 1707, the city of Philadelphia constructed the townhouse, a 2-story house and market that functioned as an early city hall. This court conducted its business at the townhouse until 1743, when it moved into its own courtroom at the State House, now Independence Hall. Beginning construction in 1871, it took 30 years to construct this city hall. It was designed in the French Second Empire style by John MacArthur Jr. and Thomas Ustick Walter. Sitting atop the building, as you know, is a bronze statue of William Penn, standing 37 feet tall and weighing 27 tons. Mr. Penn's statue faces northeast and points to a spot where he signed a treaty of friendship with the local Native Americans in 1682. City Hall has 700 rooms, which house functioning offices for all 3 branches of government. This court became the first tenant in this building in January of 1877. After the official opening, reporters deemed this to be the most handsome courtroom in the country and concluded that some of the more fastidious lawyers will hereafter take only Supreme Court cases in order that they may practice in this court palace. Before we hear the first case, there are a few things I'd like to mention to counsel. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of the case, and you may then begin by stating your name and the party you represent, and please introduce your co-counsel to the court. The justices are familiar with your cases, so I ask that you avoid any unnecessary recitation of the facts or procedural history and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for any particular issues. Please remember that we do not allow rebuttal. In cases in which there are multiple parties represented by separate counsel, counsel should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when we are asking you a question. A justice's question is not meant to trip you up. Rather, it indicates there are particular issues that we want to explore further. While there's no set time limit for oral argument, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I ask that you conclude your argument. Before we call the first case, I'd like to just mention we love when we have students here to visit, and today we have a young man named Christopher Yu, who is a senior at Upper Dublin High School class of 2025, and he is interning for Senator Art Haywood. So welcome to our student, Christopher Yu. Mr. Minner, please call the first case.
Freilich versus SEPTA, representing Ms. Freilich, Mr. Thomas Klein, representing SEPTA, Mr. Robert Columbus, representing the Leader Attorney General, Mr. Tranter.
Madam Chief Justice, members of the Supreme Court of Pennsylvania, may it please.
Good morning. Let me just give a little summary, and then you may begin.
Oh, yeah, right.
Yes. Appellant in this case suffered catastrophic injuries after being struck by a SEPTA bus in Philadelphia. She filed a complaint against SEPTA, alleging its negligence. SEPTA tendered an offer to settle all of her claims for $250,000, the amount of the damages cap set forth in Section 8528 of the Sovereign Immunity Act. We granted aliquotter to determine whether this cap on damages is unconstitutional as applied to appellant's circumstances as violative of her right to a jury trial found in Article 1, Section 6 of the Pennsylvania Constitution, or her right to a remedy found in Article 1, Section 11. We also asked the parties to address whether Section 8528 of the Sovereign Immunity Act is severable from the remainder of the Act if we were to find it unconstitutional. Thank you. You may begin, Mr. Klein.
Thank you, Madam Chief Justice. My apologies for getting in the way. I'm Tom Klein. I represent Haley Freilich, the plaintiff and the appellant in this case. I'm here with Andra Latiker, who is known to the court, and I'm here with Chip Becker, who's allowed me to argue today.
Did you arm wrestle for the privilege?
It was more than an arm wrestle. I'm here on the two principal questions before the court. I know that the court is very familiar with these questions and these issues. This dates back to both a decision which was made by this court in Zoflik. We are not here to re-argue the Zoflik case at all. And also following that, two concurrences. The one joined in Zoflik by the chief, and the concurrence in Grove City, which was joined, of course, by Justice Dougherty and Donahue and Mundy. So those gave us a reason to be here and to narrowly craft a case involving Haley Freilich, where she has been constitutionally deprived, both to a right to trial by jury as well as a remedy under the Remedies Clause. Having reviewed those cases, Yannikos in particular, I believe that she has been deprived both a right to trial by jury and a remedy. We have a case here where Haley Freilich, following the prescription that was defined in those concurrences as to putting before the court a developed record, which we have. We can demonstrate to the court that before her liens, she would get 1% of the stipulated verdict and judgment in this case, and she would get nothing when the liens are paid. I won't recite the exact facts and figures unless the court would like me to do so, but they're well familiar to the court, and this case presents the perfect storm. We are here today to ask the court to rule on the Haley Freilich case. We are not here to establish policy. We're not here to rewrite legislation. We're not here to declare any facial challenge to the constitutionality of the cap. We get it. I was here. I have the scars on my back to show for it, and that's been argued and passed. But what we do have in front of the court is a very defined challenge, and it's an as-applied challenge with two issues in mind.
Can I ask you a question on that, Mr. Klein? I understand you've taken up Justice Baer, the late Justice Baer's invitation to develop that record and done it admirably.
Thank you.
When having developed that record, what about the legal analysis changes? How does the analysis that you asked the court to apply to these questions different? How does the constitutional analysis that the majority, I think the unanimous majority in Zoflik applied, change?
The analysis changes very much like Parker Matos when there was a change in circumstance, where we are not making a facial challenge to the constitutionality of the cap. We understand that the tripod of that statute, the fact that sovereign immunity is waived, sovereign immunity having been abrogated on a common law basis and then put into a statute with exceptions and with a remedy. The constitutional analysis here is the intention of the legislature in that remedy, where also in establishing a right to a trial by jury, where the legislature affirmatively chose to not only protect the public purse, but also compensate victims. And Ms. Freilich here, we narrowly tell you, cannot, under the Constitution, have any access to the court because she gets nothing, or nearly nothing. And she also doesn't have a remedy because there's no remedy to be given to her under, by the way, any rubric of scrutiny that you apply.
Mr. Klein?
Question.
Oh, go ahead, Doug. Go ahead.
If I could just briefly follow up, Chief. I guess my question is, by hypothesis, there are innumerable, if not innumerable, there are many, sadly, many plaintiffs who could mount a challenge similar to Ms. Freilich's, indisputably beyond the having damages and liens, et cetera, well beyond the cap. And so were the court to reverse here and strike down the cap as applied, I don't see in principle the difference between that and a facial challenge. The argument still has to turn on whether jury trials were available before 1790 in these cases, which I'm not sure where you're going with that. And on the remedies clause, if the Constitution instructs that suits may be brought against the Commonwealth in such manner, in such courts, and in such cases as the legislature may by law direct, it seems like it's still a problem that they could therefore say you can't bring any cases at all. So if they could say this entire category of cases gets $0, how could we say that any given number arbitrarily is inadequate? In other words, what I'm trying to say is I still don't see the difference between, I realize you've done what Justice Baer and his concurrence urged was a development of a record. At the end of that rainbow, though, I don't see the difference. Let me stop and see if you have anything to say to that.
That was a lot.
That was.
And not a question.
Yeah, well, that's why I said, would you like to,
So there you go.
would you like to tell me where I'm wrong, what I'm missing?
Well,
Rachel Maddox back.
respectfully, a lot. I don't see it in those terms. First of all, to take you up on something, even by the studies of this, most recently 2022, when the legislature went about studying this issue, what they found is that there's fewer cases that you think that meet this criteria. And what we've had here is a right that was granted to the citizenry. And that was an affirmative act by the General Assembly. And that General Assembly Act said that they were going to provide compensation. That there was going to be a remedy provided. That remedy is not being provided. The public purse is being protected. It was two parts, and it was studied before the act in the in the wake of the Melee decision, which abrogated immunity, and then reestablished, and then with a purpose. And that purpose has not been fulfilled here. That purpose has essentially eroded over time. We might be having a different discussion if we were back in 1978, ironically, when I began to practice law. So I've lived this has been my entire legal career. And what we've seen is inflation take it up. In this case, we have $78,000 which were spent on the development of the damages in this case, with liability admitted in this case. And the medical bills are $500,000. There was a disability policy. $500,000. That wouldn't have been the case when a $250,000 cap, which has never been changed. The governor was making $78,000 at that time. Today the governor makes $234,000. The cap is $250,000. What could you expect to happen from that, Justice Weck? What you could expect to happen from that is a diminution of that to, in some cases, zero. And in this case, zero.
Could I follow up? Excuse me. My concern, and just speaking from my own perspective, you make a persuasive argument. My concern is practically, how would we go about this and what could happen? Let's say we agree with you and we strike it for one of the reasons that you put forth. We can't rewrite legislation. That is not up to us. Let's say we gave the legislature 6 months to rewrite it, which we've done in other cases. When does it become constitutional as applied? You know, is it 500,000? Is it $1 million? Each trial judge is going to have to determine with, line items if in that particular case, as applied, it's unconstitutional. Where do we go from here if we agree with you?
I don't think you need to go, given that a lot of thought, by the way, I don't think you need to go any further than to decide this case. If you decide this case, which, by the way, in the Grove concurrence, and again, I know they're Justice Baer's words, but they were also adopted by some of this court and some members of this court. And if you just look at that, if you, in his words, strike the cap, I don't use the word strike. I don't think you need to strike the cap. I think you need to say that the cap as applied here is unconstitutional. We've agreed to a verdict in this case, therefore should have been reduced to a judgment. It was reduced to $250,000. And what needs to be done here is simply strike the cap. My view, respectfully, humbly, and I could be dead wrong, but I believe that the legislature will go to work. The legislature, and Justice Baer was saying this, needs a wake-up call. My word, they were told so in 2014 in polite terms by 3 members of this court. They were told in 2019 politely by this court. 11 years has passed since Grove. 5 years have passed. And where are we? Nowhere. They're still studying it. They're introducing bills. But that's not your concern here. Your concern here is Haley Freilich. Your concern here is one woman's case who gets nothing.
Well, counsel,
nothing.
Mr. Klein, I mean, we certainly are concerned about that, but we're also concerned about how the law develops, because our opinions develop the law in Pennsylvania.
Of course.
So to say our opinion here is just going to impact your client, I don't think is necessarily a fulsome statement. We are going to issue a decision in this case that's going to go beyond your client. But if you could say, tell me, sort of finish this sentence. The cap is unconstitutional as applied when
the right to trial by jury is abrogated and there is no remedy for the plaintiff.
Okay, so you're okay. What, but,
I
so,
might modify it and say no real remedy, but
Well, I mean-
but therein lies my answer.
so can you monetize that for me? Because the cap is 250,000. So let's monetize it. When the damages are, it's unconstitutional when the damages are what?
Right. Expected that question. And I'm going to give you an unsatisfactory answer, probably, which is I don't think that it's an equation, and I don't think that it's I don't think that it can be
But you gave us an
quantified.
equation.
I think it can be, if I may, I think it can be quantified by the legislature. And I think that it can be, I think, by the way, that there can be schemes other than a cap which could be established by the legislature. For example, our neighboring state, New Jersey, has only serious injuries can be brought against the sovereign entities. Well, that's different than a cap, and it's protective of the public purse. So the cap and the dollar amount of the cap is not the answer, because there are different ways to go about it in a legislative scheme. But we're not here to establish that legislative scheme. What I'm trying to do, admittedly, frankly, honestly, is to kick the legislature
That's
into...
not our job. It's our job to rule on a question of law, not to try to supervise the
I'm
legislature
not asking you-
or encourage or discourage legislation. That's all policy for Harrisburg. To follow up Justice Brobson's question, what's the rule that because we're not just deciding Ms. Freilich's tragic case, there's all these other tragic cases out there. What is the rule that you want us to tell courts all over this Commonwealth to apply? And I still don't know what the rule would be. Is it that if there's a verdict or a stipulation over 250, then all bets are off? I don't know what the rule would be, because you can say this as an as applied challenge, but if we grant you the relief you seek, that it doesn't just extend to Ms. Freilich. So I don't know what the rule would be.
If you grant the rule that we seek, you will have ruled on the Freilich case. And we know from that case, as we know in the development of all decisional law, what some of the boundaries are, not necessarily all of the boundaries. And yes, you are correct. When I said I'd like to kick the legislature and wake them up, I think that this case will have that salutary effect, but that's not what I'm asking you to do. What I'm asking you to do is to rule on this case, and we would have to agree, Justice Wecht. I think we'd have to agree that there is no remedy here by any basis. By the way, rational basis, which I know you adopted in a recent case, or under strict scrutiny. However you look at this, no remedy is no remedy.
Counsel, you're saying there's no remedy because of a mathematical calculation, the amount of work that counsel put in, the investigations, it's a mathematical calculation as to why you reach the result that there's no remedy. But that mathematical calculation extends to cases beyond sovereign immunity cases. Pennsylvania, your minimum auto liability coverage is about $1530, and you could have a judgment-proof defendant in an auto case that has tragic injuries in excess of millions of dollars, but that person who was injured is not going to recover. Does that mean that it's an unconstitutional remedy because they don't recover?
Totally different situation. Here you have a statute which was enacted by the legislature, which, by the way, the legislature recently changed to allow for a remedy for sexual abuse victims,
but didn't increase the cap.
Oh,
they waived it. They waived it for certain causes of actions, but not this cause of action that your client is pursuing.
Yeah, yes. But by the way, proving severability, and if I can get through that argument easily, I think that that shows it. But we don't have a private compact. Yes, there are uninsured defendants. There are underinsured defendants. There are people who get less than they might be entitled. And by the way, under a cap, you get less than the value. And yes, there is a judgment call that has to be made. And yes, it's a tough call that has to be made. But the
Counsel-
suggestion...
Counsel, can I interrupt? You're giving away the barn here. I mean, the difference in the uninsured motorist case where you have somebody who's judgment proof, the government did not create your inability to recover. That is incidental to the characteristic of the defendant. Here we have a lack of recovery by design of the legislature.
I was saying it in a different way and a less artful way. Correct.
Well, I guess you could argue that we could get an argument that the legislature created a lack of recovery by setting the minimum coverage limit so low that someone who is catastrophically injured in an auto accident could never recover. And that's the minimum coverage, the 1530s, is legislatively created. And some crafty lawyer could certainly, smart lawyer can make the argument the General Assembly is denying us of a remedy because they haven't adjusted the minimum coverage for decades.
I'd like to think of myself as less than crafty, or not that description, but the
Brilliant, savvy.
Well, I don't know.
Insightful.
I don't know. I'm trying to do my best for Haley.
Did you have that seminar in law school that we had called Crafty? You didn't have that one?
I missed that, obviously, because I needed Justice Donahue at my rescue on that one question. But what I do see here is something completely different. Because as I was praying for this argument, the one thing that I saw as different is that there was a compact made with the citizenry. It was how we are going to go about this. And they decided, by the way, in their lack of wisdom, not to have a cost of living increase. In the most draconian of capped states, there are cost of living increases
I understand
or some
that
kind of inflation adjustments.
I think is a strong argument that you have that they've given with one hand and taken away with the other, that the remedy is illusory and that it defeats the remedies clause. My question on that is this. It doesn't just say shall have remedy, it says shall have remedy by due course of law, and then the next sentence is suits may be brought, etc., in such cases as the legislature may by law direct, which suggests that they can make it illusory. In other words, with law, with due course of law, in effect, in a tragic case like Ms. Freilich's, deprive you of that remedy. So, like brass tacks in the hard cases, that constitutionally they can choose to deprive her of a remedy she would otherwise have. Why? Because it is by due course of law that they chose in their cruelty and in their ignorance, benightedness, to prescribe. How would you respond to that?
I think it's just the opposite. I think by due course of law means that that if they've provided a remedy, it shall be a real remedy, not something that is illusory. I frankly think it's just the opposite. And I think that what we have here is exactly that. If this constitutional scheme that they had a cost of living adjustment, let's just say, for sake of argument, and the cap by the recent study shows that it would be worth $1.1 million today. Haley Freilich would have had some remedy, not a full remedy, and maybe not a remedy with which I would agree, but she would have had a remedy.
Would she have a remedy here if they accepted the tender of the $250,000?
No.
None.
None.
When did they tender the limits?
I think at or around trial, I might be wrong.
After she had a couple $100,000 in liens.
Yeah, she had $500,000 in liens. By the way, first priority liens by Aetna. That policy, which is part of this record, says that they're first priority liens. She owes money. She owes money. And that can't be right.
Counsel, can I ask you a question that goes back to basics here? It's Justice Donahue. I must be throwing my voice since you're looking over there.
Oh, no. I see you and I know where you are.
How did the legislature pick $250,000? What was the intention of the legislature when they chose that number all those many years ago?
It was ill-conceived,
but what was the purpose?
It was to protect the public purse.
No.
And it was
well, part, but I mean,
but it was.
They didn't extinguish remedies. What they did is they modified the remedy, and they had to have something in mind as to what that $250,000 was going to provide as relief for a wrong. So where did $250,000 come from?
Yeah, I don't know that I can tell you with specificity.
But
So,
doesn't there have to be a reason, even if we applied rational basis, which we don't, under the remedies clause, we apply intermediate scrutiny. But even if we applied rational basis, there has to be an explanation for the choice of the cap. Where was $250,000 intended to provide as recovery for?
It was, I think, intended to provide for most modest injuries which occur, not catastrophic injuries.
Can they do
And it
that?
was-
Can the legislature do that? Can the legislature discriminate between individuals who are catastrophically injured and provide no relief versus providing a benefit for somebody who slips and falls and breaks an ankle?
Gee, that might pass through some intermediate scrutiny analysis, but I don't think so, and I
Why
don't think so.
Why don't you think so?
Well,
Doesn't
I
that
start with
violate
the-
our Constitution? Doesn't that violate Article 1, Section 26 of our Constitution? The anti-discrimination clause?
Probably, yes. And I would add that an additional problem is that at or about the same time, the legislature adopted the Political Subdivision Tort Claims Act, which provided for $500,000 as a remedy. That has never made any sense to me. They protected the Commonwealth purse, the Commonwealth having a much larger capacity to pay claims, twice as graciously to themselves than they gave to political subdivisions like Shamokin Borough. So just to pick a place. So you know, you can't attribute rationality to that statute, and I've just, maybe wrongly so, accepted, okay, this is the starting point that I have here, and I'm going to go about proving that this statute cannot and does not compensate an individual. And how can that be when the government gave a right, not some statute which regulates how much an individual must insure themselves, but rather what the
Counsel.
government's willing to pay.
Counsel, if we follow your argument and we find that it is unconstitutional and severable, understanding that the intent of the General Assembly is to protect the Commonwealth's monies, is the end result limitless liability on the Commonwealth until the General Assembly revisits? Is that what you're suggesting and proposing? And if so, how does that not fly in complete contradiction to the purpose of the cap, which is to protect the Commonwealth's monies?
Well, I would start here, and I'll try to be brief. I would start with 1973, when the Political Subdivision Tort Claims Act was declared on a common law basis wrong, and there was a period of 5 years when there was no cap. Interestingly, in 1978, and I promise to answer, when Melee was enacted, it took the legislature 2 months to get a statute passed. And yes, the Commonwealth would be exposed. Yeah, I think so. Under whatever you write, they'll be exposed. And if you were to say that a plaintiff such as Haley Freilich gets no remedy, no recovery, it's as applied unconstitutional to her, well, there might be some other case or two or three out there that might fit that rubric. The sky won't fall and the Commonwealth won't disappear. I know it's easy for me to say, trust me, but trust me, it's not going to happen. Actually, catastrophic cases are few and far between. against the Commonwealth. That's the truth of the matter. That's what the studies show. That's what the study of the state Senate showed. It's part of this record. Few and far between. But the larger problem is the catastrophically injured person who doesn't have a remedy. There's no remedy. And we can now get into a debate what number would be a remedy. And I'm going to put that rabbit in the hat because it's out there. Would $50, would $500, would $5,000, would $500,000, what's beyond de minimis? Geez. I'm down here and you're up there. So, I don't know that I can provide that answer, but I can tell you what I see on its face here is that she has no remedy, and there's, and yes, it would expose, yes, Your Honor, it would expose the Commonwealth, but I would suggest it will likely expose the Commonwealth for some short period of time when they get to it. When they get to fixing it, and then you can look at it through a different prism. You can look at it through the prism that the genuine and the earnest and the purposeful actions by a legislature who now understands that you can get to zero with the erosion of time of the purchasing power of money of $250,000. That's for me, the come on category.
Mr. Klein, you agree, though, that if we issue the decision that you want, in response, the General Assembly could constitutionally just get rid of all the exceptions to sovereign immunity?
They could.
In which case, no one will recover against the Commonwealth because the Commonwealth has sovereign immunity. And that's constitutional in your view?
They can rewrite the statute to exclude certain provisions, yes. But
Well,
I'm not operating.
I'm saying get rid of all the exceptions.
Yes. Yes, but I go broader than that. They could rewrite a different scheme just as well.
Of course.
And so I don't want to get into. I think if you cabin the argument the way that you have, Justice Brobson, I think that what you do is that you create a kind of a rabbit hole that you can't get out of.
But let me follow up on Justice Brobson's question. So, suppose the court agrees with you and strikes the cap, finds it unconstitutional.
I'm bringing you around.
And the General Assembly then, responds by saying, okay, we're not going to waive sovereign immunity. We're going to direct that in such cases as the legislature may by law direct, we're directing no amenability to suit. So you're conceding, I think, that would not violate the Constitution. So I return to the question, if they can say $0, why can't they say $250,000? I don't understand the point.
We're operating under the current statute as enacted by the General Assembly that purported to give a remedy where there is no remedy. You want to decide some fictional proposition that, by the way, is very unlikely to happen. So I think at that point this court would revisit, well, I think what would happen is this court would revisit sovereign immunity. And as with charitable immunity and sovereign immunity, you would be confronted probably for the first time. Hope I'm around to bring the case if all of this happens. But it would be a time when this court would have to decide, is that within the constitutional framework of right to trial by jury and right to a remedy and right to open courts? And the answer to that would be no. I think it would be a resounding no, that we're not going to go back into the 1800s again. It's not going to happen. So I don't see. Yes, I mean I think that they could pass that. That's what you're asking me. But I don't think that it would. I don't think it would stand constitutional scrutiny, let alone scrutiny under. Well, it wouldn't be sustained by constitutional scrutiny.
Mr. Klein, I was curious about something you referenced earlier, that a legislature could, rather than having a cap-based system, have a different system where cases are screened based on their seriousness, only catastrophic cases can be brought, et cetera. How would that work? How would that be defined?
Oh, there are a host of ways to do it. Some of us who have lived in this world have given it thought. The New Jersey system, I represented a woman who died in a derailment in Hoboken, and in that case, I'm familiar with that statute, which provides that only injuries which meet a serious permanent injury threshold are compensable. It essentially knocks out the whole bottom layer of the tort claims, and that's sustained. That's been said to be a constitutionally valid scheme. There are other ways to do it. There could be the legislature, since I've been asked to kind of muse about this, the legislature could establish some sensible cap consistent with current earning power, and the legislature could then have a catastrophic injury fund, which is built every year. The budget of the Commonwealth is $27 billion. The payments for the largest transit authority, I think, is $27 million. So there's capacity, since we're talking about state or quasi-state actors, to provide a fund from which I don't think they should be compensated, quote, no fault, but I think that you could create the financial capacity to be able to do that. There are people who have thought about this and should be thinking about this and have been told to think about this.
Sound like great ideas, but don't they belong in Harrisburg?
Yes.
And not in
I asked him.
Yes.
I asked him to muse.
Yes, they all belong in Harrisburg. All belong in Harrisburg. But I believe that Harrisburg has to think about them, and they're never going to think about them if a woman who gets nothing, gets no compensation under a scheme which the public purpose of the General Assembly, the elected individuals of our Commonwealth, signed by the governor, decided to compensate them. There were two parts to that compact. One, to protect the public purse, and two, to provide a remedy. And the second is violated by the erosion of time as proven in this case. And that's why I think that we have, admittedly so, threaded the needle with a small hole, but we've threaded the needle and proven the case. And cases in controversy are meant to prove individual cases, and we've proven it. That's how I see it. That's how I've seen it since the day we brought it in front of Judge Crumlish, who said that the trial court looked at this and said, compelled to reduce it, but it is an injustice. I think he used stronger words than injustice. And as we've gone up the ladder, every judge who I've been in front of, Judge Mellon in Bucks County and Zofflick, it's an injustice. In that case, she got something. And in this case, Judge Ledbetter, seasoned jurist, spoke out in concurrence, which reads more like a dissent, because it's wrong. Because it's wrong.
Well, there's probably nobody up here who thinks it's not wrong. The question is it unconstitutional?
It is wrong, and it's unconstitutional.
Because they get to do stupid things.
They do stupid things, and you get to tell them that they were stupid and correct them.
Well, we get to tell them they were stupid. We get to ask them to correct themselves. The question is, when we, in so many cases, tell the legislature, this is a matter for you, you need to fix it, you need to fix it, you need to fix it, and they affirmatively choose not to fix it, because they're choosing not to fix it, then the question is, okay, once we erected that Jersey barrier between our lane and the legislature's lane, you're asking us to pull the Jersey barrier up, and now us go into the lane that we said is where the General Assembly is supposed to fix it.
I don't think that I'm asking you to get in that lane. I just don't think I'm asking you to get in that lane. I'm asking this court to rule on the Zofflick case and I'm not asking you to do any legislating of any kind.
Yeah, if we were going to get in the other lane, in my perspective, from my perspective, we would be rewriting the statute, and you're not asking us to do that.
Absolutely not.
All right, are there any other questions for Mr. Klein? Do you have anything you'd like to close with?
I stepped into this courtroom as a law clerk in 1978 for Justice Pomeroy, and it is an honor to be here at least once in every 5 decades. And I am proud to be a member of this bar, proud of this court, proud to be in front of your honors, whatever the decision is. Thank you for hearing me.
Thank you. Well done and well said. Let's hear from your opposing counsel.
Morning, Your Honors. May it please the Court, Robert Palumbis on behalf of SEPTA. And Your Honors, I'll be addressing the first 2 issues that the Court has accepted for review relating to the constitutionality of the damages cap. Mr. Kirkpatrick from the Office of Attorney General will address the Court's 3rd question relating to severability. Your Honors, Mr. Klein has framed this case as a narrow challenge and requesting only as-applied relief. But as has already come out in the arguments, there is no way that this court can grant Ms. Freilich the relief she seeks without far-reaching consequences, well beyond this case, and radical changes to existing law. The court would need to completely reimagine Article 1, Section 11, as it's been interpreted by this court for over 45 years.
But counsel, I don't mean to cut you off, but let me cut to the chase.
Right.
The fact that you stipulated to the amount of damages, is that in and of itself not a concession that the cap is unconstitutional?
Absolutely not, Your Honor.
Why should we not see that if you agree to it?
Because the right to a remedy, the right to recover, is determined by the cap under Article 1, Section 11.
Why didn't you stipulate to the $250,000?
Because it was the same as if the jury had returned a $7 million verdict. There's no difference. In either case, there was an award that determined this was the amount of her injury, and then the cap is applied by law pursuant to Article 1, Section 11. And this court unanimously held, under the remedies clause, that that is appropriate and constitutional in Zoflick. There's no, even the concurrence in Zoflick didn't question the fact that under the remedies clause, that's constitutional. Here today, Mr. Klein confirmed he's not seeking to abrogate Zoflick. There's also no question, and again, the plaintiffs concede this in their brief, at page 62 in the opening brief, and 26 to 28 in the reply brief. There is no question that the General Assembly has the constitutional power to impose damages caps, even in cases where it allows a remedy, a case to be brought against it. So the question is just whether the General Assembly has the power to impose this cap, and it does. This court held it did under Article 1, Section 11, just 10 years ago.
But that was a facial challenge. This is
And there's no difference, Your Honor, and this is where I'm going. The fact that this is an as-applied challenge would not mean that the result of this case would somehow be narrow. The court would need to reimagine Article 1, Section 11. It would need to recognize the right to a jury trial against the Commonwealth that has never existed in Pennsylvania history. It would, under Mr. Klein's theory, connect a civil litigant's jury right to her ability to obtain counsel, which, frankly, Your Honors, is a proposition with such far-reaching consequences that it's hard to get one's mind around them.
Counsel, can we go back to a statement you've made repeatedly, which is reimagining Article 1, Section 11?
Yes, Your Honor.
You're talking about what sentence of it, because the two are totally unrelated in purpose and intent. So what part would we have to reimagine? The part that says that anyone who is injured has a right to a remedy? Or do we have to reimagine the second sentence that's been interpreted to say that the legislature can create immunity based upon sovereign immunity?
It would be both, Your Honor.
Now let's talk about the first sentence, because that's where I'm troubled.
I understand.
Because this court has gone a long way to bastardize that first sentence, but I think we still have some remaining principles involved with it. Here, the legislature did not intend to eradicate a remedy. They did not, obviously, because they created exceptions. So they intentionally decided that for certain injuries, there would be a remedy. Are you with me so far? Do you agree? That's what the exceptions do. They provide a remedy to someone who's injured by the negligence of the Commonwealth.
Up to $250,000.
Well, fine. You could say that whenever you want to say it. But they agreed that there was going to be a remedy in that circumstance. My question to you is, in a case of a catastrophic injury, like we have before us here, there is no remedy. So the intention of the legislature is not effectuated in a circumstance of where we are today with a catastrophic injury. Is that okay?
Your Honor, this court unanimously held in Zoflik that it is okay, and here's why. Because the right to remedy in the first sentence is necessarily limited in cases against the Commonwealth. That is what this court unanimously held in Zoflik.
That was because we were looking at the exceptions, and there wasn't a direct challenge to the amount of the remedy as applied to a catastrophic injury, which essentially has been admitted here. I get your point as to the stipulation, but I think we would all agree that a $7 million verdict would be representative of a catastrophic injury, correct?
Yes,
and I think that's where we got in this case, that we have a situation on the record where we have a catastrophic injury for which there will be no remedy. We didn't have that issue in Zoflik.
I disagree, Your Honor. That was the issue in Zoflik. There was a $14 million verdict and a $500,000 cap, and the cap was challenged as a facial matter, and this court held that the right to a remedy under the first sentence of Article 1, Section 11 is necessarily limited by the General Assembly's power under the second sentence to eliminate any remedy, which Mr. Klein has admitted it can do constitutionally, or as a lesser restriction to cap the damages against the plaintiff.
Doesn't the cap have to be, I'm going to use the lowest standard, rationally related to something?
Yes, Your Honor, and this is.
And what would that be?
Well, Mr. Klein cited the 2022 report that the legislature commissioned in response to this court's rulings. What that report shows is that over the entirety of the cap, 0.2% of all claims against the Commonwealth were for claims over $200,000, meaning approaching the cap, not even hitting the cap. So 99.8% of claims against the Commonwealth come under the cap. But, Your Honor, those 2.2% of claims account for 39% of the budgetary impact of the claims against the Commonwealth. What the legislature constitutionally and appropriately did through the cap was to strike a balance. It is certainly tragic and not fair to the individual who is burdened by the cap. There is no question about that.
What number are you talking about, the $250,000 or the $1.1 million that they think would be the current day equivalent of that number?
The number in the report is the $250,000. And I will add that the report also looks specifically at the decade between 2010 and 2020, where the impact of inflation would be the greatest, and it was still 0.2% of claims were over $200,000, and those claims accounted for 39.2% of the budgetary impact. So even if we're looking at the time period where the legislature has let the cap sit in recent years after this court's decisions, there is a completely rational basis for that choice, Your Honor. And it's a choice that this court has said repeatedly in Smith, in Zoflik, that the legislature has complete control over. That's this court's language, complete control in Smith versus City of Philadelphia, a case which, again, the plaintiff says she is not seeking to abrogate. Justice Wecht, you asked a question about how relief in this case could stand next to that reasoning, and it can't. There is no way it can, and the plaintiff certainly hasn't offered any. Hasn't offered any in its brief, and it hasn't offered any today. I'd make another point, Justice Donahue. The cap was set in 1978. Obviously, inflation has changed the value of the cap over time. In the trial court in this case, plaintiff produced an expert report that said the value of the cap today, accounting for inflation, would be $843,000. If Ms. Freilich had been awarded $843,000 instead of $250,000, she would have received nothing in this case. Same exact result.
But there would have been a rational explanation for why the legislature picked a number.
The rational explanation for why the legislature picked the number is in the 1978 joint report. What the legislature did was to rely on similar caps in other states and to candidly admit that it was going to try this cap as a balance and then see how it worked out. And the way that it worked out is that the cap is sufficient for 99.8% of all claims since 1978.
Is that because claims aren't being brought because of the cap?
No, Your Honor, I don't think it is. At least since 2010 to 2020, there are 76,000 claims that were brought. It's not for lack of
Well below the
claims.
cap.
No, total claims. But again, the 39% budgetary impact of that 0.2%, that's a tremendously outsized impact of the large claims. And Your Honor, that's with the cap. So one has to ask oneself what the effect would be of raising the cap. That is a rational basis. This court has said that's a rational basis. In Smith, in reasoning that Mr. Klein doesn't ask this court to overrule. In Zoflik, in reasoning that this court unanimously chose and is not being asked to overrule. What the court is being asked to do is fashion an as-applied remedy with no legal rule, no guidance about how to do that. Would $843,000 be sufficient? Well, Ms. Freilich would still get nothing under that. Her
But
insurers
in fairness,
would be paid.
we're not being asked to craft a remedy. We're being asked to declare something unconstitutional as applied and leave it to the legislature to choose whether to recraft the legislation.
Madam Chief Justice, I respectfully disagree with that. Because this is an as-applied challenge, Mr. Klein is saying that specifically he's only asking for a remedy in this case. That something will have to be done. The court could strike the cap on an as-applied basis, and then what? In Mr. Klein's world, she gets $7 million. But is $7 million the minimum amount that's needed in order to vindicate her right to a jury trial or her right to a remedy? If the answer to that question is yes, then the court will have effectively struck the cap on a facial basis. And that is a recipe for potential unlimited liability. It will put juries and trial judges across the state in control of public budgets in a way that...
But counsel, you've told us that there are so few cases that exceed the cap. What's the danger of that happening? Your point is we just don't have very many cases against the Commonwealth that exceed the cap. So if we struck it in this case on a facial basis, that might be the end of it as applied. If we struck it out wouldn't that be the end of it?
No.
Until 4 years from now when another case might pop up?
No, Your Honor. It would be a starting gun for future cases. If the court were to say that as-applied challenges like this one were permitted, then the court could expect the trial courts to be dealing with this issue in every case where the cap potentially applies. And, Your Honor, I want to make sure that Your Honor...
2% of the cases?
I'm sorry?
2% of the cases
Your Honor,
bump up against it?
Please remember the second half of that. 0.2% of the cases with 39% of the economic impact on budgets. 0.2%, 39% of the economic impact. 4 out of $10 that the Commonwealth has spent for claims have gone to the larger cases. And that is with the cap. If the court were to just take the cap out or allow it to be taken out by trial judges on an as-applied basis, it is obvious that that 40% would jump and jump. It would, in a case like this one, just by way of example, SEPTA's budget for claims in a given year is $28 million. So this would account for 25% of SEPTA's whole budget for claims. That's going to affect services or fares.
Did they buy insurance?
SEPTA is not insurable. And many other municipalities, agencies are not insurable for the same reason. They're providing essential services. They have no choice to get out of that business. I would say, Your Honor, I also want to let the court know that of the 0.2% of cases where the cap is at least approached, 80% of them arise in areas of policing, corrections, transportation, and higher education. These are core services that the Commonwealth provides.
Is that math that you were going through a moment ago, counsel, the 0.2% and the 39% perhaps a reason why the Constitution says in such manner, in such courts, and in such cases as the legislature may by law direct, because the legislature has to weigh these things and
Correct, Your Honor.
not this court.
That's exactly right, Your Honor. That's exactly right. And if the court were to attempt to begin that weighing process on its own, it would have to write principles from scratch, because they don't exist in American jurisprudence today. They don't exist in this court's jurisprudence, and they don't exist in the jurisprudence of any other state in the country. Because, Your Honors, no court of last resort in this country has ever struck on an as-applied or a facial basis a statutory damages cap against the sovereign. This
Counsel,
court-
so your argument is, in such cases, includes in cases where damages fall below $250,000. That would be in such case the General Assembly could provide.
I would say it's also is located in Article 1, Section 11 in such manner.
Well,
language.
right, but
Okay.
you're saying that exercise in such manner and in such cases extends to the exceptions and exceptions where the damages are below $250,000. So
yes,
maybe, I don't want to call them small claims, but certainly not large claims.
No, I mean, I'm saying that I think I'm understanding your question, but the legislature has the ability to eliminate its liability
Well,
altogether.
they have the ability to allow lawsuits against the Commonwealth lawsuits that will generate up to a certain recovery.
Correct, and the plaintiff agrees with that.
So how do you respond to the plaintiff's view, though, that ignore that by simply creating an exception? Ignore the cap. They would have the cap be a separate thing from the waivers. That you just focus on the waivers.
Right.
By giving the waiver in and of itself, that circles back to the first sentence of Article 1, Section 11. And once they give the waiver, the first sentence kicks back in. Ignore the cap. And then you evaluate the cap against the first sentence.
Right.
So how do you respond to that reasoning, that the cap is an exercise of the first sentence and not the second?
The court rejected that argument squarely in Smith versus City of Philadelphia. What it held is that the second sentence encompasses the ability to cap damages, and that's logical and required because the ability of the legislature to eliminate the remedy altogether, which it clearly has, and Mr. Klein concedes, must necessarily include the lesser power to limit damages. The court said that any other holding, this is the court's words, would be absurd or at least unreasonable. Mr. Klein has admitted he is not seeking to overrule Smith, and he's not seeking to overrule Zoflick, where this court readopted that. So, I mean, on the remedies clause, there, as far as I'm aware, is no precedent today for Mr. Klein to point to, at least with respect to Article 1, Section 6. There are two concurrences.
Can we stay with the remedies clause for
Certainly.
a moment? And let me ask you the same question that I asked your opposing counsel. Can the legislature legislatively discriminate between individuals who are catastrophically injured and those who are not?
Yes, Your Honor, and the court held as much when it rejected the equal protection challenge unanimously in Zoflick.
And we've overruled that decision. Our jurisprudence on Article 1, Section 26, the non-discrimination clause, provides that, true, they may not have to confer a benefit. That's absolutely right. But once they do, they need to confer that benefit so that no one is being deprived of a civil right, which is what the challenge is here.
I'm sorry, Your Honor. The court has never overruled that holding in Zoflick.
But we've overruled the precedent underlying its Article 1, Section 26 holding.
Not with respect to the Commonwealth's ability.
Well, that's my question. Can the Commonwealth violate Article 1, Section 26 by doing what it does here, creating a remedy for catastrophically injured Pennsylvanians and those who are not catastrophically injured?
It can, Your Honor, under its express authority under the second sentence of Article 1, Section 11, to determine the manner, the courts, and the cases in which it's sued.
But Article 1, Section 26 expressly says that the government cannot unequally confer or deny benefits so as to deprive a civil right. We've interpreted civil right to mean constitutional right. So you make the argument repeatedly, as I think your co-counsel does, that you can't violate the Constitution with the Constitution. But I think based upon Article 1, Section 26, you can.
Your Honor, I'd make 2 points. First of all, to repeat myself, the court rejected that exact opinion in Zoflick. Secondly, Mr. Klein and the plaintiff have not raised that question at all. So I understand your point, but it is beyond the question that this court has accepted for review. And now, Your Honor, we're into the world of straightforward facial challenges to the cap, not a narrow as-applied challenge. And that's the point, is that this isn't a narrow as-applied challenge. The court will immediately get to the facial challenge, which it unanimously rejected, and which Mr. Klein doesn't ask the court to overrule.
Well, this is, I agree with you. I have a hard time seeing this as a narrow as-applied challenge, but it is narrow in the sense that it's as applied to those with catastrophic injuries.
Yeah, yes,
I have
Your
to
Honor,
agree with you.
that principle, if that's the principle that this court were to apply, it would create a catastrophic injury exception to the cap. And that would be the result of it. And first of all, Your Honor.
We couldn't do that, really. I
But
mean,
that's
we
what
would
the
have to
effect
say
would
it's
be.
unconstitutional.
But
We
that's
wouldn't create an exception. We would say it's unconstitutional.
So again, the remedy in this case needs to be determined. The court could say it's unconstitutional as applied to Ms. Freilich, but it needs to determine a remedy. If the only remedy is the full award, then the court will be saying that in this context, the right to a remedy demands a full award.
Well, the question-begging aspect of it in that context would be jurisprudentially more problematic than a facial challenge, because it would trigger a case-by-case parade of cases against which courts would be deprived of any standard to decide is $7 million enough, or is $5 million enough, or
Right.
4 or 3 or 1. So am I right about that?
You are right about that. There's no judicially discoverable or manageable standard that's been articulated by the plaintiff that exists in this court's law or that exists in American jurisprudence. It doesn't exist, Your Honors, because for hundreds of years, sovereign immunity has been upheld and understood to be a core right of states in this country. So a statutory damages cap or a statutory invocation of sovereign immunity has never been struck down, never, in American jurisprudence. So the court would have to write new principles, Justice Wecht, you're exactly right, some guidance for trial courts, or else we've just got a free-for-all. Or else some trial judges, I mean, this will happen even if the court does provide some principles. Some trial judges will say, in this case, $1 million was sufficient. In others will say $5 million was sufficient. Your Honors, I would just point out, if the award in this case were $1 million, Ms. Freilich would then take home $30,000. So I have no idea. Is $30,000 sufficient? Does this court have principles that it can adopt to say that $30,000 is sufficient but 0 isn't? Does she need to take home? And the effect of $1 million would be her insurers would be repaid. The plaintiff's counsel would receive a greater fee, and she would take $30,000. Would that be a vindication of her right to trial? I don't know whether Ms. Freilich would go to trial so that she could personally take home $30,000, but one can reasonably question whether a plaintiff would do that.
Then we would have no idea what 350-odd common pleas judges might do.
That's right, Your Honor, and be putting those judges in a position to directly control the budgets, or at least a portion of the budgets, of the Commonwealth, of its agencies, and every municipality in the state. It would be to give the judiciary a form of legislative and executive control over the public purse. That's the effect of even the narrow, as-applied challenge that's being put before the court. It still has that effect, and it can't be avoided.
Counsel, can I take you back again to the test that we apply to a challenge to the remedies clause? And we've Justice Mundy wrote the opinion. Most of us agreed with the conclusion that an intermediate scrutiny applied to it. And in that context, do we not look to see if there are other less intrusive ways that the legislature could be doing what it intends to do?
Yes, Your Honor. If intermediate scrutiny were to apply, that would be the outcome. And in Zoflick, the court applied intermediate scrutiny to this context and held it satisfied it under the equal protection challenge. So it's passed that test.
And
It also
suppose we-
passed that test in Smith.
And
This-
suppose we did that based upon this notion of a distinction between catastrophic and non-catastrophic injuries. Would you say that Zoflick and Smith control that outcome also?
I would, Your Honor. It would, because the General Assembly is picking a balance that's closely related to a core government interest, and that balance is supported by the evidence.
But isn't the question, is there a better way to do it, a less intrusive way to do it? I mean, if there's and it is a significant government interest. I mean, and this sort of flows from the notion, we don't write legislation. All we do is look at this and say, is there another way that they could have accomplished this that doesn't so intrude upon the right to a remedy for catastrophically injured individuals?
The test is whether the cap is closely related to an important government interest. There's some question as to whether there are other avenues out there, but it's not strict scrutiny.
No.
It doesn't have to be the least
No.
intrusive.
Are there other
and
other methods?
I'm not aware of any other methods. There are 37 states in this country that have damages caps.
Yeah, but,
Pennsylvania
I mean,
is at the
Mr.
the
Klein listed 5 or 6 different schemes that are used elsewhere. Not for us to suggest that our legislature use any one of them, but it's an example of the fact that there are other mechanisms available to achieve the same goal.
There are certainly other mechanisms available to achieve the same goal.
Well, I think
But-
one of the examples Mr. Klein gave was that one state only allows a waiver of sovereign immunity for catastrophic injury, and others, not whatever doesn't mean catastrophic injury, you can't sue for.
That strikes me as an even greater equal protection issue.
No, but see, they're eliminating the remedy entirely. Here, that is not what's happening. I understand what the case law says on the point, but here, the legislature clearly intended to provide a remedy for anyone who is injured by the negligence of the Commonwealth in the 7 or 8 exceptions that are there. In the situation that Justice Brobson just described, they eliminated the remedy. I
But
mean,
it's
I'm not
still
in favor of that analysis, but that's the analysis that we use here, freezer storage, et cetera, et cetera.
Respectfully, Your Honor, it's still a blatant discrimination between catastrophic claims and non-catastrophic
But they
claims. So the question would be the
decided not
same.
to provide a remedy in that situation.
Okay, well, I think it would still be the same discriminatory choice in your view.
Not under our convoluted remedies law analysis, which allows them to totally eliminate a remedy, which
It
is,
allows them to totally
We're
eliminate.
going to clear up. We're going to clear all this up.
Yeah.
Mr. Columbus, we understand your argument. Would you like to wrap up?
Your Honors, I think you've heard my points. I appreciate the time today, and I'll defer now to Mr. Kirkpatrick from the Office of
Thank
Attorney General. Thank you.
Good morning, Madam Chief Justice, Justices, may it please the Court, my name is Sean Kirkpatrick. I'm here on behalf of the intervener, the Commonwealth of Pennsylvania, through its Attorney General. And I'm here to talk a little bit about the severability, non-severability, but before I get into that, because I think it directly impacts that discussion, is a concern I have, which is even if this court is able to cabin this decision to as applied to just this case, if I am a common pleas judge and I have another catastrophic case coming before my bench, I'm going to need to decide, do I sever this cap in this case as well? Throughout this litigation, there does not seem to be a governing principle, let alone a limiting principle that has been articulated. There has not been a number. And so what goes to my mind is, let's imagine it's the exact same situation as Ms. Freilich experienced, but instead of a SEPTA bus, it was a bus by the Indiana County Transit Authority, who has, and they are amicus in this case, has an operating budget of essentially, I think, $5.2 million, and a rider, number of riders is about 240,000. This kind of $7 million verdict is existential to them. Should the trial judge take that into consideration? The health of the defendant, which would be curious in a constitutional analysis, and gets into that weighing of the public interests that the legislature is best equipped to do. It could easily be a Philadelphia School District bus. Again, another amicus, they said that that would be the equivalent of 84 teachers.
Or it could cause the SEPTA to be less negligent.
Well, Your Honor,
Those types of verdicts cause organizations and businesses to reevaluate.
for businesses, Your Honor, they either go out of business, and it hurts their shareholders, it hurts their owners, it hurts their employees and maybe customers. A catastrophic case, Zolflick involved, I believe, 20 students, $14 million. The result of that is students or citizens who depend upon the public transportation. You're right, obviously, any kind of cap, any kind of damage, let me put it that way, should put in mind the idea that you want to limit damages so as to protect the public purse. I don't think that if the legislature raised it from $250,000 to $1 million, it would, SEPTA would say, oh, well, we can't be reckless anymore. These are accidents by definition that are unplanned. So again, we get back into a balancing test. On one hand is recovery for parties, whether catastrophic or otherwise, who are injured by Commonwealth and municipal employees. And on the other hand is preservation of the public fisc. And so when we get into severability, and again, I believe, as this court has said in many cases, that kind of balancing of public interests is best done by the legislature. I think it was, Richley versus North Penn School District, which said that when the scale is weighted on both sides with legitimate interests, this recognition should end the inquiry. So let's talk about severability in this case. And that would be, again, I'm not sure what the number is, I'm not sure what the test is, but I suppose the question posed to this court is, if you strike down the cap, must you also strike down the waiver? Now, we recognize that there are 10 waivers under the Sovereign Immunity Act, and the 10th one dealing with sexual abuse has no cap. So it wouldn't make any sense in our minds to necessarily strike that one. And again, it depends on what kind of order this court issues, or what kind of rule this court issues as to whether, like, I suppose if it's an as-applied case, only applied to Ms. Freilich, we would be dealing with the first waiver of sovereign immunity, which is vehicle liability. But when looking at whether one of the two exceptions to the general presumption of severability applies, the touchstone, as this court has said, is legislative intent. And I think the clearest legislative intent is actually the language of 8522A, which says that the General Assembly, pursuant to Section 11 of Article 1 of the Constitution of Pennsylvania, does hereby waive, in the instance set forth in Section B, those are the enumerated exceptions, only, and only to the extent set forth in this subchapter and within the limits set forth in Section 8528, which is the statutory cap. So in writing this statute, the General Assembly, within the limits set forth in Section 8528. So if this court were to hold that the caps in 8528 must fall, this waiver must fall with it as well, because they are inextricably intertwined. And in our brief, we talk about the history, we talk about the Joint Commission in, I believe, 1978 or thereabouts. And I think it is relevant that in Miley, when this court struck down common law sovereign immunity, it took 2 months for the General Assembly to reassert that immunity in, was it
2310.
152, Act 152 of 1978.
Carroll versus County of York. It was Carroll versus County of York. That was the first case, wasn't it?
Yes, afterwards.
You're talking about section 2310 that they passed?
Yes, 2310, yes. That's exactly right, Your Honor. I apologize for the confusion. Which was passed, it was enacted and signed by Governor Schaap on September 28th, 1978. A date that sticks in my mind because it's the day I was born. So for my entire lifetime, the General Assembly has made it its express intent that there be sovereign immunity. Now that's, again, Act 152. Act 142 of 1980 was the codification of Sovereign Immunity Act and the Torts Claims Act, which sets the waivers and also set the caps. So it is our position, and I think it is the only fair reading of not only 8522A, but also the history, that should this court, on an as-applied basis, whatever that means, feel the need to sever the damage cap, it would also need to sever that waiver as applied to Ms. So as to have no waiver of sovereign immunity in this context, because the General Assembly would not have wanted to waive sovereign immunity if it was going to be unlimited. If the court doesn't have any questions, I stand on our briefs.
All right, thank you.
Thank
Well
you.
done. And may I just compliment again all counsel on your oral arguments and also on the quality of the briefing in this case. It was extraordinary, along with the amici briefing. So thank you for all that input. We will take it under advisement. Thank you.
Thank you.
Mr. Minner, would you call the next case?
Commonwealth of Pennsylvania versus Aplt Sanchez, representing Mr. Sanchez, Mr. Neil Harrison Jr., representing the Commonwealth, Mr. Aplt.
Next case is Commonwealth versus Sanchez. Per statute, this capital case comes to us directly from the trial court. In 2008, appellant was convicted of murder for fatally shooting 2 individuals and of attempted murder for shooting another individual who survived. In 2017, appellant was granted a new trial. While he was in prison awaiting retrial, appellant solicited 3 individuals to murder the surviving victim from the 2008 shooting. The trial court consolidated the murder and solicitation cases and in 2023, appellant was convicted of 2 counts of first-degree murder, attempted murder, conspiracy to commit second-degree murder, 3 counts of solicitation to commit murder, and a number of other offenses. Prior to the penalty phase of trial, appellant's counsel informed the trial court that appellant did not want any mitigation evidence presented on his behalf. The trial court initially denied the request, but after extensive colloquies, reconsidered its decision, finding that appellant had a constitutional right to waive the presentation of mitigation evidence. As a result, the jury found several aggravating circumstances, but no mitigating circumstances, and the trial court imposed a sentence of death as required by law. Before this court, appellant raises both guilt phase claims, including challenges to the sufficiency of the evidence, and penalty phase claims, most of which concern the absence of mitigation evidence. Counsel, although there is no time limit for argument, given the number of issues that you've raised, you may want to focus your argument on what you believe are your strongest claims, knowing that this court will ultimately consider all of the issues raised in your brief.
Good morning, Justices, and may it please the Court. My name is Niels Erickson. I am the attorney for Mr. Sanchez. I'm also the Chief Public Defender for Bucks County. Chief Justice, while I agree that all of the issues that we've raised in our brief are significant, I want to focus my time this morning solely on the death penalty and the capital mitigation issues, if I may.
All right.
It is our opinion that there were 3 critical errors that were committed by the trial court in this case that require a new penalty phase hearing. First, he was denied the opportunity to argue mitigation evidence that already existed in the case from the guilt trial portion of the case. Second, he was denied the ability to have the E8 aggravator, the catch-all mitigator, that any evidence of mitigation, including the character, record of the defendant, and the circumstances of the offense. And third, the jury instructions that were provided telling the jury that there was no mitigation in this case, as well as telling the jury that ordinarily I would tell you to weigh aggravating versus mitigating circumstances, but that does not apply now. I believe that was an unconstitutional jury charge.
Why?
And the guilt phase and the penalty phase are different in that regard?
I'm sorry?
Waiver of the mitigation in the guilt phase and in the penalty phase should be treated differently?
No. No. I recognize that my client was his own worst enemy in this case. The concern that I have in the argument that I make is that the trial court conflated waiving of mitigation evidence with waiving of any argument by me as his counsel for a life sentence.
So what are you specifically talking about? There was certain evidence that came out during the actual guilt or innocence phase of the trial itself, such as intoxication, age, a number of other factors.
Correct, and I listed them on page 50 of my brief, correct.
Right, so we get to the actual penalty phase, the defendant stands up and says, I don't want to present mitigation, right? At that point, Judge Rubenstein then prevents defense counsel from arguing those mitigation factors that came out during the course of the trial, and he gives the jury instruction, said there is no mitigation, which is essentially a death sentence.
Absolutely correct, and
That's your argument.
That even if my client wants to make the wrong decision of saying, I don't want the presentation of mitigation evidence, which under Sam and Puskar and Rega and Telford is his right to do, I should still, as his counsel, be able to argue for a life sentence.
Well, in essence, this defendant at some point decided he wanted to be put to death, and then he changed his mind.
No, those are, no. In the PCRA context, this case is unique, and I believe it's a first impression in that most of the cases that this court has decided, Rega, Sam, Puskar, Telford, were always in the PCRA context, where at trial, the trial court said, fine, no mitigation evidence. Rega is one of my, I hate to say this, but favorite ones, because Rega says, argue all you want, just don't talk about a psychologist, I don't want to talk about the psychological issues, and don't put my mother on to tell me about what a bad childhood was. this court said, hey, he made a choice. He didn't want this mitigation evidence, but he wanted other mitigation evidence. The attorney still argued the mitigation that he had, and then a death sentence was issued. But I'm coming to you directly from the trial court where I was trying to argue mitigation evidence, that the transcript is a heck of a read, in this case that should have been presented.
Counsel, just so we're clear, the defendant didn't say he wanted to be put to death. He told the judge, I just want the jury to follow the law.
Correct. Now,
So it wasn't like he said, I want to be put to death, tell them to put to death, there is no mitigation.
yes and no. He
You
says-
sure there's a no piece to that? You want to argue that?
Yes, he says, I want them to follow the law. To which Judge Rubenstein and Mr. Sanchez then engage in a hypothetical. What do you think that means? And he says, well, it could mean death. And is that what you want? Well, if the following the law means death, then it's death.
That's not, I mean, I understand you're trying to recall the exchange, but I'm not sure it was a hypothetical. The court said, and what would that be, in your opinion, the defendant? As far as you know, taking it from you, and you know the facts in the case, and the sentence should be death. That's the law, so let it be. The court, do you believe that should be the outcome? The defendant, I believe that, yes. We'll have a full inquiry. You're choosing to, at least in the hypothetical, which I guess is where you got the hypothetical language from, be executed rather than having a chance to serve out your term as a life prisoner, correct? Defendant, yep.
Yes, that is absolutely correct as far as which.
So how is that not him basically saying, I'm ready to go. Sentence me to death. Let's get on with this. I mean,
I don't believe that this court wants a sentencing structure in which the defendant can plead to a death sentence. I believe, as I presented in the McKenna case, that there are greater societal interests at stake when the issue is sentence of life or death.
well, I know, but the question we're here is whether your client waived making a mitigation argument versus presenting mitigation evidence. Your argument is he waived mitigation evidence at the penalty phase, but in no way did he intend to waive me arguing mitigation against death penalty.
Yes, one, I agree, because it was never asked of him, do you waive mitigation, or do you waive any argument by your counsel? And number two, I believe that even him suggesting that I should have the right to waive is not something that this court should find as proper in this case.
So you're asking us to issue a ruling that says that a defendant convicted of first-degree murder cannot waive mitigation and agree to the death penalty?
He can waive mitigation. The case law, as much as I disagree with it, stands for the fact, but I believe his attorney can still argue for a life sentence and should be allowed to use.
What if he doesn't want a life sentence?
I don't believe that we should allow a defendant to plead to death. Okay, I believe that there is a greater societal interest in having.
Well, but who are you as defense counsel if your client goes to you and says, I don't disagree with you, by the way. I think conceptually I'm right, but from a jurisprudential perspective, you represent your client. You don't represent society. And your client says to you, shut up, sit down. I don't want you arguing for life. They're going to put me to death, and I'm good with it. Are you saying you can override that out of some societal interest?
Yes, I believe it doesn't matter, and I don't mean to be flippant. I'm going to try and say this in the simplest way possible. It doesn't matter what my client thinks the evidence and the verdict should be as to sentence. No more than it does, and there's a line of cases, Boses versus Oklahoma, Booth versus Maryland. The Commonwealth can't put on a verdict and say, this is horrible, and in my opinion, jury, he should get death. They can't put on a detective to say, this is horrible, and jury, in my opinion, he should get death. I can't put on my client's family to say, this is horrible what happened, but the verdict should be life. I can't put my client on to tell the jury what he thinks the verdict should be. That's irrelevant to the jury's analysis of weighing mitigating and aggravating factors.
That's not what I asked you. I asked you, during the penalty phase, can a client instruct his or her lawyer to sit down and not address the jury?
I don't believe that that's part of the fundamental rights analysis under Mason, under McCoy versus Louisiana. I don't believe that that's part of the fundamental rights. What my sentence.
If your client chooses death as opposed to maybe the cruel and unusual punishment of isolation in death row, what gives you the right to tell him what's best for him when he's telling you, as counsel, don't argue it. I want to die. I don't want to spend 22 years locked up 23 hours a day.
Well, counsel, let me reframe the argument a second, because I think we're going off a far afield. I don't mean to interrupt, but we're framing this, or at least some members of my colleagues up here are framing this as a defendant's right. Doesn't the jury have a right to hear all of the factors at its disposal before it renders a decision? In other words, if the Commonwealth is going to present aggravating circumstances, and if there are mitigation circumstances, before a jury actually makes that ultimate decision, doesn't the jury have a right under our jurisprudence to hear all of the factors that are necessary that go into its decision? In other words, we don't want the jurors 5 or 6 years later coming back and saying, gee, if I had known of mitigation factor A, B, C, and D, I never would have given him the death penalty. So can't we couch that as a societal right, or at least a jury right?
I would agree with you, which is why I suggested in the brief that this court should give some consideration to that long list of cases. I don't think they're going away, considering the nature of the death penalty in this Commonwealth, as well as defendants realizing that nobody's being executed. I think we're going to see more of these waiver of mitigation issues.
The jury is supposed to be the decision of the jury is based upon the evidence presented, and it's up to the defense or the defendant to introduce or not introduce evidence for the jury to consider. It's really not the jury's business as to learn about evidence that a party chooses not to submit to the trial.
Justice.
I'm conflicted with both Justice McCaffrey and your response to that question, as the jury should trump a defense's introduction or not introduction of evidence relevant to the outcome of that criminal matter.
Justice Doherty, your position is the current state of Pennsylvania law. I happen to agree with Justice McCaffrey's hypothetical.
It's the other Irish guy up here.
Share with me or tease that out. What makes the jury have stronger rights to understand evidence that the defense or the defendant does not wish to be introduced?
Again, it goes back to the McKenna case, where there's a greater waiver is wonderful, except that there are times when the issues of interests of society overplay that.
That would be if your client's incompetent, or if your client is temporarily insane. Not if the client knowingly, willingly, and intelligently tells counsel, I don't want that in there.
No, but that's not what this court held in McKenna in 1978, if I remember correctly, in that McKenna had been convicted and sentenced to die under the old death penalty statute. The Supreme Court of the United States found that that statute and many others were unconstitutional, and so all of the defendants then went to appeal their sentences. And McKenna says, nope, I'm good. I'm not going to. I want to die. I'm not going to appeal what has been clearly determined to be unconstitutional. And I forget the procedural, how it came about that it actually got in front of this court, but this court said he may prefer death, and that may be his genuine interest. But waiver was never intended to be a means of choosing your own sentence. Societal interest in justice always outweighs a defendant's interest. The standards in which this death sentence or life sentence are set must be beyond reproach. That's the words of this court in the McKenna case. So there is a greater societal interest that we have to be, as a society, confident that the standards used to find a death sentence for someone are beyond reproach, which did not happen in this case.
Counsel, I'm trying to understand, though, what actually happened in this case. Did you make these arguments to the trial court judge?
I'm sorry.
Did you make this particular greater societal argument with the
No, my head was...
Judge, you know, I know my client doesn't want to talk about mitigation, but there's this general societal interest that I need to inform the jury of, and you need to let me riff and go off and go on this, and he's fine. And, I mean, did you make that argument? I thought we were here simply because the question was, did your client waive new evidence or waive mitigation argument entirely?
Did my client waive mitigation evidence? I believe the answer is yes. Under the current state of the law,
Right.
the colloquy as found in Sam was followed.
Right.
My position is he did not waive, nor should he have waived, or nor can he waive the mitigation argument by his counsel.
Why can't, okay, so I don't remember the part, I remember the part in your briefs about he didn't waive it. The trial court erred by saying, by waiving the evidence, he waived me from being able to argue the evidence that was already in the record.
Correct.
I don't remember you saying that he can't waive, that there's some rule against waiver.
I don't think my argument was as nuanced those mornings than it is today, correct?
Okay.
But I did raise the fact, in day two that morning when we came back after, and I raised the arguments that following morning, saying that my client, that I have the right to still argue the mitigation that's in this case.
But you were raising that as your client has the right to make those arguments, not you have some individual vested.
No, correct.
Yeah, right. So the issue, really, the only issue before us is not the societal question that Justice McCaffrey was pointing or that you were responding to. It's simply looking at the record. Did your client waive the ability to make a mitigation argument based on evidence incorporated from the guilt phase?
Well, two arguments to that. Number one, I don't believe that question was ever asked of the defendant, so I would say that he did not waive.
Well, you're giving me the answers. I'm just saying, is that the issue?
Correct. Well,
that's the issue.
Well, there's lots of issues, but as to, I think.
But isn't that outcome determinative? Isn't that answer outcome determinative?
That's
I mean, that's why, I mean, I understand your societal interest points and everything else that we've talked about, but, and I think the trial judge did an excellent job. I think the trial judge did the very best to get everything on the record that was required, including having your client meet with the witnesses who were there to testify. But as I read the colloquy, I didn't see it to encompass that latter point. Was he aware that there was evidence that was already on the record? He wasn't going to have to put his family members to the task of appearing and saying good or bad things about he and his life and family. But did he waive the right to have the existing evidence argued on his behalf as mitigation? And I don't think he waived that. I mean, correct me if I'm wrong.
I agree with you, Justice Donahue. He did not. Those questions were not asked. To the extent, was this a satisfactory colloquy for waiving mitigation evidence? Yes. To the extent, was this a sufficient colloquy that this court should be satisfied he waived any argument for a life sentence? I think the issue is no. But going back to your original question, I believe this is the gatekeeping issue, that I don't get to those other issues that I'm arguing if I don't win this issue. If this court feels he waived everything, I'm dead in the water. So
But I'm confused then, because if, as Justice Donahue phrased it, and that's a good approach, that the question is whether he specifically waived the right to have mitigation-type testimony that already existed in the guilt phase argued and presented as argument in the penalty phase, that wasn't how it was sliced and presented at the trial court. Was it? Was that how you presented it as an issue, and was that in fact waived?
I made the argument that I should be able to argue mitigation that already exists in the case. I agree with Justice Donahue that the trial court, under the circumstances, I think all counsel did an excellent job. But I don't know that Justice Rubinstein was hearing what I was arguing. I'm not saying that correctly, but was not. He saw it as waived, therefore game over. I thought it was more nuanced than that.
I could see how that would happen, given the length of time and effort that was put into the colloquy. But as I recall, the request that was made is to argue evidence already of record in support of mitigation. He said no. Now, that part of the mitigation that your client was waiving, I didn't see that anywhere in the colloquy.
You're absolutely correct. It does not appear in the colloquy. I'm sorry.
So he wasn't colloquied about that. He wasn't colloquied about the specific information that came out during the course of the trial and said, you can present this evidence to the jury as mitigation. He was just foreclosed by Judge Rubinstein's decision.
Correct.
So I just want to be clear, and I think the record's pretty clear on this too. There was a colloquy. You asked about presenting the mitigation evidence that came out, which is set forth on page 50 of your brief, which is youth of the appellant, alcohol, drug intoxication, homicide incurred during the drug deal, et cetera, et cetera, et cetera. The evidence that he was, for lack of a better expression, objecting to had to do with his childhood, and he didn't want to put his mother on.
Correct. Or his family, correct.
But at no point did he ever say, by the way, I don't want you to present that evidence that was presented during the course of the trial as mitigation.
Correct. And
So what we're talking about here is a court-assisted suicide, right?
correct, I agree with you. Yes.
As Justice Marshall would say.
Counsel, can I just, let's say we agree with you. Let's say the trial court erred by not allowing you to, because I think the Commonwealth incorporated the record from the guilt phase and into the penalty phase.
Right.
So by the time you stood up, the record was there. And let's say, looking at the record, it doesn't appear that there was a waiver specific as to making argument on evidence already there. What does that mean? What is the remedy?
The remedy.
Is it to go back for another penalty phase, or?
Correct. The remedy would be to go back, I have other issues that I'm relying on my brief on.
Well, let's say that's the only one you win on.
Then, yes, the remedy is a new penalty phase hearing in which the Commonwealth will present their aggravating circumstances and the defendant can waive.
And they can present the evidence that was in the record, or do we have to have a whole nother trial on guilt phase?
That would be a discussion between whoever is the district attorney and the counsel for Mr. Sanchez at the time of that resentencing. But the remedy would be a resentencing.
Not a retrial, but just a resentencing.
Well, I'm sorry.
No, re-penalty phase trial, that's what you want, right? You
Well,
want the hearing on the penalty phase, you want that to,
If you're going to get a new jury, right? You're not going to bring back the same jury, right?
Correct,
So
absolutely.
you're going to get a new jury. My question is the transcripted record of the previous trial adequate in a penalty phase trial alone, or will this new jury be entitled to hear live witnesses?
and that changes the question that's before us. Should he have been allowed to argue mitigation evidence that was already presented?
Well, it was the same jury, I think, though, wasn't it?
Yeah. But
Well, yeah, but I mean, if we rule on that basis and he gets a new trial and presents new evidence, that's a whole different ballgame.
Correct. There would have to be a new jury sworn, and the Commonwealth would have the choice, frankly, in how they want to present their case. Do they want to present it by offering a stipulation to the trial testimony, or do they want to present it through live witnesses?
Well, I guess probably the more important question would be, would your client want to allow stipulation of the prior record cold to the new jury?
I don't know. I'm not going to speculate what my client's thinking is going to be at this point in time. There is a lot of...
I think I could.
That's one of my concerns, that I hope that this court, regardless of what you decide in this case, will provide some clear guidance, because given the status of the moratorium, it's on, it's off, given the status that Pennsylvania has not executed other than somebody in 1999, there is a real temptation to mess around and find out on behalf of these defendants. And I think that was what was going on here. Is the only thing, and the trial court picked up on it in some of its statements. The only thing he can control at this point is he's trying to control what the only thing that he can control. So I hope that this court will give some guidance as to how this procedure should be played out.
Along this line, I just have one quick question. After the guilt phase and prior to the penalty phase, when the trial court was colloquying your client, didn't he make it clear that if you got up and made any presentation to the jury with regard to mitigation factors, that he was going to get up and testify to contradict whatever was told to the jury with regard to mitigation?
He did say that, but my recollection is that he was referencing, if I put those witnesses on, then I'm going to get up there and rebut what they said. But I think that it's undetermined what he meant by that, which is not sufficient as far as a colloquy would go.
Yeah. And as far as your ethical obligations to your client, if your client tells you he does not want mitigation evidence presented to a jury, aren't you bound by that? Like, you really didn't have, despite the trial judge's ruling on an evidentiary matter, as a matter of ethics, if your client asked you not to do that, aren't you ethically obligated to follow his wishes?
I would hope that in the capital context, when the issue is death versus life, that would not be so. I can tell you with all candor that the only person in that courtroom that knew the law was my client. That the Commonwealth, nor myself, nor the trial judge, as it played out, we all researched the law, but at the time this went down, the only one that actually knew the law, and if you look at my client's initial request that morning, I'd like to waive mitigation, denied. I want to represent myself, denied. In hindsight, that's how it should have gone down, is that if he wants to waive mitigation, then he can represent himself. He was the only one, in candor to the court, that knew the law at that time.
Yeah, I appreciate the difficult position that you probably were put in.
Mr. Erickson, you make a very interesting argument, and at the conclusion of this case, I would recommend that you write a law review article. All right, let's hear from Mr. Alka.
It has been an honor. Thank you, Justices.
Thank you, Chief Justice Todd. Good morning, Your Honors. Eric Alcon for the Commonwealth, appellee in this matter. There seems to be a little bit more waffling over the record in this matter than I would have hoped. And while I recognize that this is oral argument and Your Honors are familiar with the record, probably have it in front of you to a certain extent, if the court would indulge me, I would like to read two portions of the record from the penalty phase that I think flatly answer this question.
Okay.
The first portion is from May 3rd, 2023. Notes of testimony, page 7, and just for a little bit of context, this is a back and forth between the parties where the parties were discussing whether or not the verdict slip would say presence of mitigating circumstances essentially within the guilt phase record, as Attorney Erickson wanted, or whether or not the verdict slip would say no mitigating circumstances presented. So that's the context. The court says, okay, I've seen them both. I have to make a decision based upon the evidence and the state of the record. We are going to utilize one that states none presented, because that is exactly what has happened. Are we ready for the jury? Mr. Erickson, so I cannot argue any. The court, you cannot argue it. Mr. Erickson, and my only argument can be follow the law. The court, I'm going to tell them that. Mr. Erickson, that's fine, I just want the record clear, presumably, and well done preserving the record for this issue before Your Honors. Fast forward a day prior to the colloquy this is from appellant's counsel, Mr. Sanchez's counsel. It's a direct question, back and forth exchange that goes like this. This is appellant's counsel. And you understand that if there is no mitigating evidence presented, that all counsel will be able to say to the jury is that there is no mitigating evidence being presented and you simply want them to follow the law. Appellant, yep. All counsel will be able to say to the jury is there is no mitigation. That's what you want? This is paraphrasing now. Yep.
But counsel, that begs the question, was there mitigation evidence in the record? Because all of those colloquies are, if there is no mitigation evidence, but that's what I'm struggling with, is there is mitigation evidence in the record. In fact, the Commonwealth is the one that put it in the penalty phase. So all these tee-up questions don't seem to address the scenario of, you understand there is mitigation evidence in the record. Are you sure that you don't want to argue mitigation, or is it that you just don't want to present new additional mitigation evidence?
Respectfully, Your Honor, I cannot imagine a scenario where you look at this record and you can find an avenue within the record to conclude that Mr. Sanchez's desire was not to present additional mitigation, but he was perfectly fine with zealous advocacy based on mitigation within the record.
I'm just responding to the quotes that you read, because all the quotes you read had a qualifier, if no mitigation evidence is presented.
Well, I would argue that that qualifier is just forecasting what will happen, which is that there will be no mitigation evidence.
Well, there was mitigation evidence, though.
I disagree with that, because there can only be mitigation evidence of record when counsel presents it. It is not for the jury.
Well, you did. The first thing that the Commonwealth did was incorporate the record from the guilt phase.
Correct, but
so you put the evidence in the record of the penalty phase.
Correct, but it is not for the jury or the trial court to point to evidence of record and identify for the jury what the trial court or presumably the jury would feel constitutes mitigating evidence.
That's argument.
I'm sorry?
That's argument, and that's really the issue that we have in front of us, is I can agree, it seems to me from my reading of the record, that he waived up, down, backwards, and sideways presenting new mitigation evidence to the jury in the penalty phase. What I'm struggling with is, did he waive arguing based on mitigation evidence that was already in the record because the Commonwealth incorporated the record from the trial, from the guilt phase?
I don't see a world where the quote that I just read does not contemplate that. When his counsel asks him that if we go, I understand you're getting hung up on the qualifier.
What's it say? If we don't?
I understand, Your Honor. I understand that you're getting hung up on the qualifier of if there is no mitigating evidence presented.
Right.
But
Getting hung up on the words.
Well, but nonetheless, Your Honor, that does not, the purpose of those words is not to say, well, all that is saying is that if we do what you want, that's all that's saying. All that's saying is if we do what you're asking here today, all counsel will be able to say to the jury is that there is no mitigating evidence being presented, and you simply want them to follow the law, and that is exactly what Mr. Sanchez wanted done. I don't understand how, respectfully, of course, that there is any way you can read that statement.
Well, if it was that clear, we probably wouldn't be here. I mean, and this is a serious matter. I mean, this is a very serious matter. It doesn't get much more serious.
Of course, I agree with that.
And I think your answer, that your last answer was the best answer, which the qualifier doesn't matter because he was specifically told that this is what's going to happen if you say yes to my question. Even if the predicate was wrong, this is what's going to happen. Do you agree with that that's going to happen? And the answer was yes. That's your best response, I think.
Understood, Your Honor, and thank you. However, I would go on to say that I didn't actually finish the full quote. Afterwards, there was one additional exchange. I assume that you'll have the same issue with it nonetheless, but I will read it, which says, Appellant's counsel, you understand that following the law would necessarily mean that in the absence of any evidence of mitigating circumstances, if there is at least one aggravating circumstance, then the sentence must be death. Do you understand that?
But counsel,
I understand.
that's exactly what Justice Brobson's saying.
He acknowledged
There was mitigation evidence presented in this particular case, so why don't we impose an obligation upon defense counsel that he has to present that to the jury as mitigation?
Because I don't believe there was any mitigation evidence presented absent counsel presenting it. And his
But counsel did present it. Justice Brobson went through that for you. On page 50, it literally lists 6 or 7 different mitigating factors that he could have argued to the jury constitutes mitigation.
He argued it in his brief on appeal. He did not argue it to the jury because his client instructed him not to.
And
So
the
in
court
the
wouldn't
absence
allow
of
him to. The
I don't
court
think the
wouldn't
client
allow him to. He asked the court to be able to argue those points.
his attorney did, but Mr. Sanchez did not, and he is the client. And I have not, of course, referred to any of the law at this point. I don't believe there's much disagreement on the state of the law in terms of the validity of mitigation waiver. However, if I could boil it down, essentially, the argument is under all of the waiver of mitigation case law, it is abundantly clear that a lawyer shall abide by a client's decisions concerning the objectives of representation. I think that's a key word. And an objective of representation includes things like pleading guilty, testifying on your own behalf, demanding a jury trial, or in the context of the penalty phase, presenting mitigating circumstances. So, of course, the Commonwealth would never argue that an attorney is beholden to every whim and demand of his client in terms of how to go about achieving the objectives of representation. But this issue, whether or not mitigating circumstances will be presented to the jury, that is an objective of representation that is within the client's control. And I'd like to step back and, of course, say, of course, I'm not up here arguing I think this was a good decision. I don't think anybody in this courtroom would say that this was a good decision from Mr. Sanchez. I would have preferred that it was an adversarial proceeding and mitigating circumstances were presented. Mr. Sanchez made it abundantly clear that that is not what was going to happen. And the trial court successfully did everything that it could to honor that wish. So, frankly, and with respect to Mr. Erickson and, of course, Your Honors, I think it's a little mind-boggling that we can allow Mr. Sanchez to essentially unpin this grenade, lob it into the courtroom to shake all this up. And here we are squabbling about whether or not this is actually what he wanted, when the cold record could not be clearer. I understand Justice Brobson focusing on some of those qualifiers. My argument, I understand, but my argument is still those qualifiers do not change this conclusion, which is
Can I
that.
ask you a different question?
Absolutely.
I realize you haven't address this, but am I correct that he was convicted, Sanchez was convicted, among other things, of conspiracy to commit murder in the second degree as to Thomas and Diaz?
Correct.
Is that an oxymoron? We're talking about a felony murder. There's an unintentional aspect to the killing there. How do you
Your Honor,
conspire? How do you conspire to do that?
I did note that in my brief, and there's 2 points I would respond.
And how do we deal with that then?
Sure. There's 2 points I would respond. One is a bit more technical. From my recollection, the preserved claim within appellant's brief was that there was no shared intent, no shared specific intent. I believe that was the thrust of the claim. So in my view, since second-degree murder does not call for specific intent, if that's the claim raised on appeal, then any claim beyond that would go to directly challenge whether or not this is like a cognizable offense has not been preserved. Nonetheless, if we are reaching that question, there are a few cases I cite. I believe Fisher is one of them. There was another case, Rivera, I believe, in 2020, that did address the anomaly. I suppose you could characterize it as conspiracy to commit second-degree murder. I do acknowledge it's a bit legally nebulous. However, I believe that the rationale for conspiracy to commit third-degree murder would essentially carry the day here. I know that there is case law that explicitly permits that as a legally cognizable offense.
Well, alternatively, would it be appropriate to vacate that conviction and affirm the sentence nonetheless?
The conspiracy to commit second-degree murder?
Yes.
Is that before us? I don't think we accepted that on Halpern, did we?
I don't believe that was an issue
So
preserved.
that would be your answer, that it's waived?
Well, I'd like to know a bit more about are you saying that would affect the death sentence?
Well, I'm asking you.
I don't think so, because the aggravators here were, burglary was the predicate felony. So I don't believe we're addressing the underlying burglary sufficiency with your.
No, I was talking about the conspiracy.
I don't think that was an issue raised.
Oh, I thought they did raise the issue about whether you can conspire to commit second-degree
Yeah,
murder.
there
I
is a
thought that's what-
sufficiency challenge across the board, which we have to look at, do we not?
Correct.
Issue number 2 is sufficiency to convict in a
First
first-degree murder.
degree.
There is no, I mean, that's an issue that I discussed with my clerks. We were looking for it. It was waived.
I believe so, Your Honor.
We'll take a look. We'll
Yeah.
take a look and make sure.
Yeah.
Thank you, Mr. Alcon. Thank
Thank
you
you.
all. Mr. Minner, would you call the next case?
Robert N. Halpern, on behalf of himself and all others similarly situated, versus Ricoh, U.S.A., representing himself, Mr. Robert Halpern, representing Ricoh,
It's filled in. Okay.
In this discretionary appeal, appellant purchased a digital camera, but unbeknownst to him, appellee Ricoh, who manufactured and sold the camera, had modified its design and parts, which allegedly resulted in the camera failing prematurely. Appellant brought suit under the catch-all provision of Pennsylvania's Unfair Trade and Consumer Protection Law, which prohibits a seller from engaging in any other fraudulent or deceptive conduct which creates a likelihood of confusion or of misunderstanding. The trial court dismissed this case, and the Superior Court affirmed. It ruled that appellant's case was required to be dismissed under a prior decision from that court, Romeo versus Pittsburgh Pirates, which held that a plaintiff seeking to bring such claims against a seller of defective goods or services must show that the seller had an affirmative duty to inform the buyer of the defect. The question for our court is whether the lower court's 25-year-old decision in Romeo should be overruled. Please proceed.
Yes, good morning, Your Honors. Robert Halpern, attorney pro se, and may it please the court. I think the particulars in this case highlight a gap or a fracture in the consumer protection law of the Commonwealth, in that there are situations such as this where there is a serious, perhaps defect or problem with a piece of merchandise, and there's no relief that a consumer can find under the current law because the the current law encourages sellers to remain silent in the face of a defect which they may or may not know about. But because we're bound by Romeo at this point, which requires that that silence requires, you can remain silent unless there's a duty to speak.
Are we talking about a modification or a defect? I mean, does it have to be a defect for this argument to arise, or are you talking about any modification?
I'm using the term defect very broadly. It could be any problem with the item that was purchased. Not any problem, and that's a question for the court, how the court would like to narrow what this is going to apply it to. It's called a catch-all, but I don't think we want to catch everything in a revision or rejection of Romeo. So regarding Romeo, I think Gregg versus Ameriprise leads us down this path to a large degree because, as the court knows, in that case, it was found that a strict liability standard should apply to the consumer protection law. So if we're looking at Romeo, there's really no continuing basis to require a duty. The duty that Romeo thrust upon us was really a holdover from the old common law. In the old common law, and Prosser writes about this, in the old common law there was a distinction drawn between misfeasance and nonfeasance, and the common law didn't favor nonfeasance or the lack of action. So in fraud cases, there was introduced mere silence or lack of action would not normally engender fraud, but then there were exceptions that were introduced which required a duty. And a duty could be found through a confidential relationship, a fiduciary relationship, and that duty is what Romeo was referring to, the duty which was found in the old common law of fraud. But once we get to looking at it as, once we look at this CPL as, well, if we look at the plain language of the CPL, as the court in Gregg said, there's really no reference to a duty that is within the plain language. So we're arguing that there's no need for that duty to be, there's no need for that duty to be imported into the CPL.
Counsel,
Yes.
can I ask, what would you suggest the disclosure should have been in this case?
The disclosure should, well, we didn't have any discovery, but based upon...
Well, you knew what was wrong with it. I mean, what should the manufacturer/defendant have said about this product?
They should have disclosed that there were problems with the aperture that would lead to the likely malfunctioning or unusability of the camera possibly within several years.
And how about the warranty that said you can rely on this product being operable for a year? What does that do?
The warranty question is interesting because my friends on the other side, they've been arguing that they can just rely on the warranty. The warranty, they say, sets the expectations. But the warranty doesn't really set the expectations about the product. It sets the expectations about what you expect the seller to do. If I have a 1-year warranty on the camera and something happens after 1 year, I can no longer expect the seller to be
Counsel, are you indicating that a blog should provide the basis for the extent of its usage? Didn't you base this upon some blog you read and introduced? As opposed to the 1-year warranty, it's some blog said, oh, these types of cameras should have 100,000 photos as opposed to, correct?
Well, that was part of the facts, that it was said that the cameras...
So going back to Justice Donohue's question, you're saying a year, which was guaranteed, should be extended to 7, but your introduction of evidence that camera should have been X number of photos before it turns black. Your argument's conflicting with what your brief says. I'm asking you to straighten that out for me.
Okay, I'm not arguing that it had to last for a certain number of photos. I'm arguing that it was sold with a defect, a defective aperture mechanism that
Counsel, what-
rendered it unable to last through its normal lifetime. So it wasn't really,
What's the normal lifetime? I think that issue kind of segs into the whole issue of the warranty. Because you're alleging a defect, and I'm going to go back to the duty question. If there's no duty, you can't have a material misrepresentation. So in this particular case, you're saying that they made some modification, which I think is what the chief asked you beforehand, on this particular solenoid. But that's not a representation or warranty made by the actual seller. It was on some kind of third-party blog, as Justice Doherty pointed out. So what's the defect you're alleging?
we're alleging that the solenoid in the aperture should have been made of a different material. The material changed over time, and in certain cameras, in 2 models, they used a solenoid made of a different
Is that a
material.
defect or a modification? Is that a defect or a modification? Doesn't that go to the kind of the merchantability of the product itself? I mean, the product was still working.
Well, no, after the defect manifests itself, you're just getting black pictures in many situations.
Yeah, but the defect manifested itself, according to your pleading, after 5 or 6 years. The warranty only lasts for 1 year.
Right, but we're saying the warranty should not determine consumer expectations. The warranty is really just what the manufacturer or the seller decides to give you.
But this is where I'm confused. Your evidence in the record is based upon this third-party blog. That's what you argue. But now you're not arguing that. I'm asking you to qualify that.
Well, I don't think in the record I was taking certain facts from the postings, but it was my own camera that had a defect and stopped working.
After 5 years.
Correct.
It didn't stop working. The pictures were darker than you would appreciate, or did it absolutely just show up as black photos? That's not what I read in the briefs. Correct me if I'm wrong.
It suddenly, I didn't use this camera that often. So it was a lightly used camera. And then one day I started using it, and it suddenly, and other people had the same experience, started producing black images. As I explored it a bit, I discovered that in bright light, you could get some pictures, but the aperture is actually frozen, so you're only allowed one opening, and that'll work in bright light, but it's not going to work in many conditions.
Counsel, can I ask a follow-up question? And here's where I'm confused, because I agree with you what Greg says. I mean, and the statute itself creates a duty, so that, you know, a manufacturer or seller can't engage in otherwise deceptive conduct. But I'm grappling with what the deceptive conduct is here. I know that you think that they should have advised the purchaser of something. Okay, and in this case, it's that the aperture will malfunction or will likely malfunction in 5 years. Is that what you're saying?
Well, we don't know in how many years it's going to malfunction.
Well, you see, that's what I'm troubled with here. What is it that they were supposed to disclose? I mean, the fact that, I mean, it could be that the knob on the front of the camera is known to fall off in 10 years. Do they have to tell a purchaser that the knob is going to fall off in 10 years? Is that a problem that has to be disclosed, or is that just what happens after 10 years of use of the knob on the camera? Same thing with this aperture. And I may be talking about something that ultimately goes to discovery, but I'm challenged by what the deceptive conduct is here.
The deceptive conduct is that the camera is not performing to minimal levels of performance.
Who says so? Who says that? That's what I'm struggling with. Maybe they only last 5 years. Maybe the aperture only lasts 5 years. That's why my first question to you is, what was it that you would have liked them to disclose to you on the packaging or an insert or something like that? What were they supposed to say?
They were supposed to say that the aperture is not operating properly. It's not going to last through the normal life of the camera. And not only will it not last, it's going to be very expensive to repair.
What's the normal life of the camera?
Well, we posited 100,000 pictures. That's just, an
And
approximation.
that's the basis of the third-party blog you read? Yes or no?
Correct.
Well, counsel, we're getting into the weeds here, and I wonder if, I guess let me see if I understand the claim. This case was tossed on POs, and what you're asking us to do is send it back, having overruled Romeo, and send it back to apply under the amendments, the 96 amendments, and Gregg on the deceptive conduct paradigm. Whether or not you win is beside the point, right? It's a question of whether the paradigm, the legal paradigm, was correct. Isn't that, in other words, you don't have to convince us here of the proof. The question, I thought, was whether Romeo's the wrong paradigm. Isn't that the issue?
Yes, that's correct, and I don't think I can convince everyone on the proof because we don't have.
No, you might still lose, is my point. My question is that you don't need to prove us 100,000 apertures or whether this fact or this warranty. I thought you're just asking us to send it back under the non-Romeo, under the Gregg paradigm. Is that what you're seeking?
Correct, but I would also add to that, we would suggest that just looking at the CPL might not work, and my friends raise a lot of concerns about the CPL. We're talking about omissions rather than affirmative statements.
Understood. I understand you're asking us to say that under Gregg and under the 96 amendments, you can have a misrepresentation by omission, consistent with the FTCA. Isn't that the point?
Correct, and you may want to go even further and say that these omissions have to be, I don't think material works, but go to the minimum performance level of what a consumer would expect.
So we do have to decide a legal question. We have to decide whether this claim, assuming the facts that you're saying, falls within the definition of the catch-all. Was it unfair or deceptive, basically as a matter of law? Is this the kind of claim that the General Assembly meant to fall under this catch-all provision? That's the legal question. I'm struggling with why you don't have a breach of warranty claim that's barred by the statute of limitations. Because if we side with you, then the statute of limitations for breach of warranty goes out the window, and all breach of warranty claims are now going to fall within the catch-all of the unfair trade practice and consumer protection law. Why am I wrong?
I understand the concern, but it's a separate claim. If we're going to tie the CPL to warranty, then you're just going to eviscerate the CPL.
But what you're arguing is warranty. You have said that the camera is defective because it is not operating for the expectancy of the life. It's violating the warranty of merchantability. All these implied warranties that we recognize under Pennsylvania law that are actionable. You're saying, but you're barred by the statute of limitations. You're saying, oh, well, that's not a problem because it was deceptive because they sold me a product that wasn't suitable for 100,000 pictures, the useful life. That's a breach of warranty claim.
They sold me a product that was defective, and the judge, since the CPL claims are heard by the judge, is going to have to decide in what way I'm using defective broadly, in what way was it not fit for use, or whatever, however.
Right, but that fit for use is a warranty claim, is an implied warranty claim.
Well,
fitness for purpose, fitness for use, merchantability, those are warranty claims, and I'm trying to say, which the General Assembly has said are subject to a certain statute of limitations. I'm trying to understand, is it your argument that this catch-all provision includes breaches of implied warranty?
No,
so how are they different? How is a catch-all claim under the Unfair Trade Practices Act that you're trying to bring here different from a breach of implied warranty claim?
The catch-all claim is that it's likely to mislead or confuse the consumer. If the omission is likely to mislead a consumer, then it falls within the catch-all.
Does the omission have to stem from the unequal bargaining power that prompted the General Assembly to create the Unfair Trade Practices Act in the first place, meaning an omission of a fact that is solely within the knowledge of the manufacturer or the seller.
No, I don't think so.
So as long as if it's a publicly available fact, because we all Google now and we buy a lot of stuff online, and there are a lot of reviews on Amazon, for example. If there's a review posted somewhere that says, "Hey, do not buy this camera. This camera sucks. It has a bad aperture, all other stuff," but you're not a researching consumer. You buy the camera anyway without going out there to the blogs or whatever, and it has the failure. You're saying doesn't matter that that the information was out there, was generally available to everybody. Caveat emptor is kind of out the window. If somebody puts a product up and there's a defect in it, they have to affirmatively disclose it to me before I buy it, even if it's out there. That's your view of what that clause captures?
I would go so far as to argue for strict liability, that even if they had an obligation to disclose it, whether or not they even had knowledge of it.
Well, my question is, if it's deceptive, if the statute says deceptive, then they have to be they have to be deceiving you. And how can somebody deceive you with information that is generally available to the public?
I agree. In that case, if the consumer had knowledge, let me backtrack a bit.
Or could have had knowledge. Knew or should have known. If the consumer knew or should have known before buying the product that the product has a certain solenoid that might fail within 4 or 5 years.
I don't know that I would go that far, because then we're putting the burden on the consumer. And when we read cases about the CPL,
that's caveat emptor.
Which I thought we started.
I'm sorry.
Justice Robson started with a question about the warranty, and I'm just reading the warranty. You have to help me with this. It says that REOC warrants to the original retail purchaser for a period of 1 year from the date of purchase against defects in material or workmanship. Now, you're alleging, I believe, that the problem with the aperture is a defect in the material?
Right.
Does this mean nothing, this 1 year warranty limitation?
It means something, but they could have given a 3-month warranty. They could have given...
They could have, and you would have bought it knowing that that's what you were purchasing, a camera that had a 3-month warranty, and you'd have looked elsewhere because you could have probably gotten one with a 1 year warranty. But I mean, I'm trying to decide what the intersection is here between a warranty against defects for a year, and what you're suggesting is that 5 years later, if I find out that there's a problem, I have a claim under the catch-all provision of the Unfair Trade Practices Act.
I'm trying to unhitch the CPL claim from warranty claims.
How? That's why I'm asking you how. Are you saying maybe the warranty is a defense against the claim as opposed to an affirmative bar against the claim?
No, I don't think the warranty is really in the picture at all.
Okay, because?
You're not, see, it seems to me you're getting tangled up here by walking down that path. I thought from the briefs that your argument is that you're entitled to get to discovery on your claims of deceptive conduct without the paradigm of Romeo confining you. That you're entitled to show deception by material omissions. That you may have a really hard road to hoe here, but that you ought to be able to try to hoe it. I thought that was the argument.
I mean, that is the argument, but I'm taking it a step further, and maybe I'm just causing a bit of confusion. But the step further is, what type of omissions are we talking about? And if you look at a case like Tomasello, which is cited in the brief, I believe it's a First Circuit case. They go through, and it's derived from the FTC. The FTC addresses this in terms of omissions, and they talk about if omissions do not meet a minimum standard, then they're deceptive. And they're not talking about warranties. They're talking about the omissions themselves, and it has to they use the phrasing has to be fit for the intended purpose. That's why I used that phrasing before. Or the
Implied warranty.
Yeah.
That's an implied warranty, fitness for a particular purpose.
Right, but they're using that phrase not in the sense of warranty. I mean, they're incorporating the warranty of.
Don't get confused by express warranties and implied warranties. What Justice Donahue was talking about was the express warranty of the product that was given by the employer. In addition to those express warranties, there are implied warranties. And I was talking about the implied warranties of fitness for a particular purpose. Yeah. I agree with you, under the law, they couldn't put a product into the stream of commerce that breached the implied warranty of fitness for a particular purpose. I think that's what your claim is coming on, but you're trying to avoid the statute of limitations to put it in the Unfair Trade Practices Act, maybe to get treble damages, maybe to get attorney's fees, maybe to bring it as a class action. I don't know, but I'm struggling with, and I'll not ask the question again after this, is what is the difference between a breach of implied warranty claim and this claim you're trying to bring under the Trade Practices Act?
Well, it depends how omissions get defined. So we're using the broad term omissions. It's probably too general because it's going to incorporate all kinds of problems. So it's probably going to have to be narrowed. Material.
You're saying we're going to have to narrow it.
You're going to have to narrow it, right? So it could be, and the FTC offers some guidance. I talk about it in my brief. But the implied warranty, I'm really trying to avoid that. And it's true. I don't want to be bound by that statute of limitations, but the applied warranty can be disclaimed by a seller. So it could be sold as is, so it doesn't even exist.
But then you know that, right? The buyer, to Justice Donahue's point, if you got on the website and you saw a camera, and the camera said, here's a digital camera, as is. We're not even going to tell you what it does. As is. Could you bring an Unfair Trade Practices Act claim because they didn't disclose a bunch of things about the camera?
If they sold it as is and they made it noticeable, then maybe not. There also has to be...
But they didn't make a particular representation about the solenoid or how long the camera would last.
Right, but as is means I'm taking it with any problems that come with it.
Okay, I think we've got this. I'd like you to wrap up, if you would.
And just, there's also the reliance component of the CPL, so they would have to show reliance, so that would address some of your concerns. And other than that, I would thank the court for its time.
Thank you, Mr. Halpern. Let's hear from Mr. Cooney.
Madam Chief Justice and members of the court, may it please the court, my name is Gordon Cooney, and I represent the Aplt Ricoh, U.S.A. Members of the court, it's undisputed that plaintiff's camera performed properly for nearly 5 years, which is almost 4 years after the expiration of the express warranty that the court has discussed, and even beyond the UCC's 4-year limit on implied warranty claims. And what would be the implied warranty claim here? It wouldn't be fitness for a particular purpose. That's when the seller knows that there's a specific use by the buyer. We had no dealings between the parties here. It could potentially be an implied warranty of merchantability, that the defect or the problem with the product was so significant that it rendered the product unmerchantable. The express warranty in this case did not disclaim implied warranties. And so the bundle of rights that the plaintiff got in this case was the 1-year express warranty, where Ricoh said, if there are any defects in materials and workmanship, we're going to pay to repair that.
Why isn't it incumbent on a company, if you know that if you use lens A, that camera is going to work for 10 years, but if you use lens B, the camera's going to work for 6 years, and you know that as the manufacturer, don't you have a duty when you sell a camera to somebody to let them know that, hey, you can buy this camera, it has lens A, it's going to last 10 years, but if you buy this camera, which is cheaper, it has lens B and it's only going to last 6 years, so that the consumer can make a educated decision about which camera they want to purchase?
So, Your Honor, I would say several things in response to that. First, I think we have to construe what the statute focuses on. And what the statute focuses on, and what the 96th Amendment focused on, was adding the concept of not just fraudulent conduct, but deceptive conduct. And so what we're talking about here is, what does deceptive conduct mean? And I can come back to what I think, if you look at the language, and if you look at the structure of the act, if you look at the legislative history of the act, deceptive does not mean that a manufacturer who has had no dealings at all with the consumer has an obligation to
Yeah, but is
provide-
that really fair, since so much of the consumer goods now are purchased over the internet, and you never have any communication with them? And
But the question is, has the manufacturer been deceptive? If you look at the way the statute is written, if you look at the legislative history to the amendment, if you look at all of the Pennsylvania cases that have construed this, and the other courts around the country that have construed similar language, no courts have held there is a duty. But let's talk about this.
A duty, can you finish what you were just saying? No courts have held there was a duty to what?
There's a pure duty to disclose in the absence of one of two things, Your Honor. One, the defendant said something that is a half-truth, that's misleading by omission. Or two, there is an expectation of disclosure that's created by the law. And there are a number of different contexts where the law does create an expectation.
Like remaining silent when that silence constitutes an implied but false representation, right? I mean, and those two things, I guess what I'm getting at, sorry to interrupt, is that those two things are at least in tension with Romeo, right? Romeo, do you think Romeo survives, Greg?
I do, Your Honor, and I do want to come back to Justice Mundy's question, because I think in this context, let me say, I think this case is actually quite simple. The question of whether Romeo survives in another context, I have a long argument about what the statute means. But here, the consumer's expectation is the 1-year express warranty that the manufacturer gave, and the 4-year backstop that the UCC gives on merchantability claims. That's the expectation, and it is not deceptive for a manufacturer to remain silent and not say, oh, by the way, this component, it might only last 5 years. That component, it may only last 7. A complex product like this has hundreds, if not thousands, of components. What would the disclosure have to be in an automobile or a computer?
Well, what if you layer on top of that disclosure of a component that the manufacturer or seller knows to be a problem, and that the general public, the buyer, would not know, and if they did know, would influence their purchasing decision?
I would say two things about that, Your Honor. First, I think the expectation of the parties is set by the warranty, and if all a plaintiff would have to do to get around the temporal limits of the warranties that have long been established under the law and under the UCC is to allege the defendant knew or should have known that this component wouldn't last more than 5 years, and so the defendant should have disclosed that, even though the only expectation the plaintiff could possibly have had is that if it's any kind of a problem with defects in workmanship, it's 1 year. If it's merchantability, it's 4 years.
Counsel, can I just add, just for clarity, that's not exactly the end of what your warranty says, because the last sentence says this warranty policy does not affect the consumer's statutory rights.
And, Your Honor, I think what that is referring to clearly is statutory rights under, for example, the UCC, which has specific provisions with regard to implied warranties.
But why wouldn't it anticipate the Unfair Trade Practices Act? That's a statutory right.
So, Your Honor, I think the question, though, again, is there something deceptive or fraudulent about a manufacturer not advising affirmatively that a component in the product might last only 5 years, or 8 years, or 9 years, or 10 years. And what would that disclosure have to look like?
Well, that was my question to your opposing counsel. I'm not certain what the answer to that is.
I think, Your Honor, the only appropriate way to think about this would be, in order to protect itself, a manufacturer would have to disclose what it understands to be the useful life of almost every different component in its product. And what the FTC has said, the plaintiff argues that a defendant, a manufacturer, should disclose all material facts. The FTC has specifically rejected that standard under the FTC Act.
Isn't your argument here that it's not a material defect, therefore I don't have a duty to disclose? And really, our question of law here is just purely, does the plaintiff have to have it, or does the defendant have to have a duty?
So, Your Honor, I would say there are several things that, several arguments that we have that are all in alignment with one another. One is, the law does not require, in order to avoid deception, a manufacturer to say what the useful life is of components of their product that are beyond the express or implied warranty period. It is not deceptive to fail to say that.
Well, you're going to open up yourself to additional liability under any contract or whatever if you have to do what you say would be, which is expressly disclose the useful life of your product. If that's what the unfair trade practice law requires, is that every seller has to have a paragraph, sort of like disclosing carcinogens in food or something. The useful life of this product is 5 years. That becomes an express warranty.
Exactly, Your Honor. And so I think the point I'm making is, A, it's not deceptive to fail to say that. B, it's a completely unworkable standard. And C, in this context, recognizing the claim, even to go forward, would effectively negate the established law that this court has recognized with regard to express and implied warranties.
Can I ask a question? I mean, I think these are good points. I just need to tease this out on the Romeo rubric aspect here. So in the briefing, there's this irreducible minimum term, right? So it's a construct, a hypothetical, right? But this is POs, so we don't know what the proof would be. So assuming this irreducible minimum scenario, where the product is not really what it appears to be, in some sense, or what it appears to be on its face, just not that car scenario, right? I assume you do not dispute that silence in that scenario could be deceptive, and if you do agree to that, it seems to me there's an issue, because I think Romeo, even in that situation, Romeo would mandate an affirmative duty to disclose to get to a jury. Am I right about that?
So, Your Honor, I think the example that the FTC cites, it posits the possibility. It first rejects the notion that a materiality standard is workable because the disclosure that would be required is so vast that it would be overwhelming for the consumer and it would bury all the important information. And think about a product like a camera or a computer or a car that has thousands and thousands of parts with different useful lives. The FTC said there might be some circumstances where the product fails to meet even an irreducible minimum standard of performance. And the example that the FTC gives is a car that only goes 35 miles an hour, but the manufacturer says nothing about it. But here, there's no issue of irreducible minimum standard of performance. This camera performed perfectly for 5 years, beyond the express warranty period, beyond the implied warranty period. And to say that the irreducible minimum standard of performance applies to 5 years, 8 years, 10 years down the road, that completely negates the protections of the warranty coverage. And it should be determined as a matter of law that that is not that irreducible minimum standard of performance standard has nothing to do with a product that may experience difficulties outside the warranty period. It's just not relevant, and it's not what the FTC was talking about in its standards. If liability were permitted here, if this case were allowed to proceed, manufacturers could not rely on the temporal limits of their own warranties and the 4-year period that the UCC has established as kind of the backdrop. And think about that merchantability standard. Merchantability and minimum standard of performance are two sides of the same coin. If a purchaser buys a product that is unmerchantable, that purchaser has 4 years to discover that performance problem and bring a claim. That's effectively the irreducible minimum standard of performance. If the product doesn't perform to a merchantable level during 4 years, there's a warranty claim. But the net effect of recognizing a duty to disclose here and that the non-disclosure that the plaintiff complains about here is deceptive would absolutely nullify settled law with regard to warranty standards.
Mr. Cooney, we understand the arguments. Are there any other questions from the justices? Thank you both very much.
Thank you, Your Honor.
Mr. Minner, we would like to adjourn until 1:15.
We're going to recess until 1:15.
Good afternoon, everyone. Would you call the next case, Mr. Minner?
Michael Tranter et al. Versus Z&D Tour et al. Representing FedEx, Mr. Robert Aplt Jr. Representing Penske, Mr. Robert Columbus. Representing UPS, Mr. Gary Stewart. And representing Apelt, Mr. David Sellers.
Mr. Columbus, you can't get enough of us, huh? This case involves complex litigation which arose out of a mass casualty multi-vehicle accident on Interstate 70 in Westmoreland County. Appellees in this case are 4 of the individuals who were injured in the accident. They filed civil complaints in the Philadelphia Court of Common Pleas against appellants in this matter. Prior to trial, appellants filed motions to transfer venue to Westmoreland County based upon the doctrine of forum non-conveniens, which is Latin for inconvenient forum. The motions included 11 affidavits from first responders and other potential witnesses who lived and worked in Westmoreland County, detailing the burdens that they would suffer if they were required to travel to Philadelphia County for the litigation. The trial court granted the motions and ordered that the cases be transferred to Westmoreland County. However, the Superior Court reversed, concluding that appellants failed to meet their burden to justify transferring the cases because they did not demonstrate that their potential witnesses were key to their defense. We granted allowance of appeal to determine whether the Superior Court misapplied the doctrine of forum non-conveniens by requiring appellants to identify key witnesses in support of their motions to transfer venue. Good afternoon.
Good afternoon, Your Honor. May it please the Court, my name is Robert Dapper, Jr. I represent Federal Express Corporation in this matter. Mr. Palumbos represents Penske, and Mr. Stewart represents UPS. On behalf of FedEx, I will argue that the Superior Court misapplied the doctrine of forum non-conveniens in reversing the trial court's order, which transferred the underlying actions to the county in which the incident giving rise to the claims occurred. On behalf of Penske, Mr. Palumbos will address the appellee request that the court reconsider the doctrine of forum non-conveniens in light of advanced communication technology. On behalf of UPS, Mr. Stewart will address any remaining arguments that are unique to his client. When preparing and filing a petition to transfer based upon forum non-conveniens under Rule 1006 in February of 2022, the North Star was Freilich. In 2014, this court provided clarity to litigants and discretion to trial courts in applying the forum non-conveniens doctrine. In particular, this court provided 5 key guideposts. 1, Rule 1006 does not require any particular form of proof, and affidavits have never been held necessary to obtain transfer. 2, there is no burden to show near draconian oppression. 3, a trial judge need not be told like a child how distance in and of itself makes things more disagreeable and disruptive to the persons obliged to travel, and it is not necessary to articulate to a jurist the inherently empirical concept that distance and expedience are inversely proportional. 4, the interference with one's business and personal life caused by the participatory demands of a distant lawsuit is patent. And number 5, the trial court can intuit oppressiveness from the job titles of the proffered witnesses. Of course, Freilich was a wrongful use of civil proceeding case against a law firm and its client, with 7 witness affidavits that describe the disruption and personal and financial hardship the witnesses would encounter by a trial in Philadelphia. The affidavits in Freilich employed nearly identical language in describing the hardship of participating in a trial approximately 100 miles away. This court reinstated the trial court transfer to Dauphin County and reversed an en banc decision of the Pennsylvania Superior Court. In this case, FedEx surpassed the Bradick record by a wide margin. Importantly, the trial court's decision in this case was not manifestly unreasonable, which is of course required in order to reverse under the abuse of discretion standard. Under the deferential standard of review, the Superior Court should not substitute its own judgment for that of the trial court, even if it would reach a different result. This court had cautioned in Cheeseman that a transfer petition should not be a tool by which a defendant may forestall litigation in the underlying case by generating litigation concerning the transfer petition. With this court's admonition in mind, the defendants in this case promptly submitted to the trial court 11 affidavits, 32 witness statements, Pennsylvania State Police reports, and National Transportation Safety Board reports. Taken together, that record established that many critical witnesses were in western Pennsylvania for a motor vehicle accident occurring 250 miles from City Hall. That record included the identity and roles of 13 Pennsylvania State Police officers from Westmoreland, Washington, and Butler counties. That record established that more than 50 injured parties were transported and treated by medical providers at 6 hospitals in Allegheny, Westmoreland, and Somerset counties. That record established that 10 fire and EMS departments in Westmoreland and adjacent counties transported more than 50 injured parties after assessing their injuries and treating them at the scene. All of that record evidence was submitted within the 30 to 60-day window afforded by the trial court to provide evidence on the forum nonconvenience issue. In particular, the trial court permitted the parties to conduct discovery for approximately 60 days, limited to the issue of forum nonconvenience. The trial court thus directed that there would not be any discovery on the merits of any claim or defense, and affording 30 days for affidavits and 30 days for depositions, again, limited to the issue of forum nonconvenience under Bradick. As argued by FedEx in its FNC petition, and as explicitly found by the trial court, the evidence in western Pennsylvania was relevant to many topics in this case. The weather conditions, including visibility for an accident occurring at 3:30 a.m. on the turnpike without any artificial lighting. The road conditions, including whether the road surface was dry, wet, or slippery on a snowy January night. The exact position of the vehicles. The location of the bus passengers before and after the collisions, including whether they were seated in the front of the bus or the rear of the bus.
Counsel, I don't mean to cut you off, but the issue as rephrased is your allegation that Superior Court misapplied the doctrine of forum nonconvenience. Can you share with, I know there are facts in this case, share with us how did they misapply the doctrine of forum nonconvenience? Let's get to the issue.
Justice Dougherty, the Superior Court misapplied the doctrine because it relied on its prior decision in the Eimer case. And in the Eimer case, first of all, it was not factually analogous. Eimer was a two-vehicle accident in which the plaintiff's vehicle struck the rear of a truck that was moving more slowly in the right lane. In the Eimer case, 3 witness affidavits were submitted, and the experts agreed that the scene was not a contributing factor in the accident. This case, of course, involves multiple vehicles, many affidavits, and the scene is paramount to the cause of this accident. But, Your Honor, even more importantly, for purposes of this court, Eimer was decided incorrectly because it relied on case law that either was no longer valid or does not apply under this circumstance. And that, Your Honor, is for 3 principal reasons. Mm-hmm. First, the Eimer decision relied principally on a case from the Superior Court in 1987 called Petty versus Suburban General Hospital. In this court's jurisprudence over 25 years, from 1989 to 2014, from Oakhurst to Scola to Cheeseman to Bradick, this court never adopted the so-called key witness requirement.
That's what's concerning me. Share with me what's your concern or what's your argument against the Superior Court adding this new requirement of identifying key witnesses?
My concern, Your Honor, is that it is inconsistent with this court's precedent, and it is based upon law that does not apply and should not apply to Rule 1006 intrastate transfers. The source of the case law on which the Eimer Court relied was as I mentioned, the Petty case. But the Petty case, in turn, relied on a federal Third Circuit case, Ricoh versus Piper Aircraft. And that Ricoh versus Piper Aircraft case involved the dismissal of a case in federal court because an interstate dismissal based upon improper form. It involved a plane crash that occurred in Scotland. And in the Petty case in 1987, the Superior Court talked about the federal law as it existed under Ricoh. And it also talked about public interest factors, which this court held in Cheeseman were not to be considered. When you take together that the Superior Court in 1987 was relying on since repudiated public interest factors, and as well as the fact that it was relying on federal court cases involving the dismissal of an interstate dismissal, Your Honor, I think that the 1987 ruling simply not as only inconsistent with the precedents of this court, but should not apply. This court addressed forum nonconvenience in Okurse, in Scalo, in Cheeseman, and in Bradick, and at no point did it expressly or impliedly hold that there was a key witness requirement.
What would you suggest that we rule as to what burden the defendant would have to show for oppressiveness or vexation?
I think that the court in Bradick set forth the appropriate rule because it provided clarity to the litigants in not requiring any particular form of proof, and at the same time clearly stating that affidavits have never been required. And it provides the trial court with the discretion in looking at the evidence. Here, Your Honor, there were 11 affidavits, there were 32 witness statements, there were Pennsylvania State Police reports, and there were NTSB reports, all provided to the court in February on February 25, 2022, for lawsuits that were filed in November and December of 2021. With the court, with keeping in mind this court's admonition in Cheeseman that a motion to transfer should not be used as a tactic to forestall litigation. As most members of this court are surely aware, there's an early case management conference for courts filed in Philadelphia County, and a finite period of time is provided for discovery. So the court was able to intuit from all the information that we provided that the witnesses, that there were many witnesses, surely dozens of witnesses in Western Pennsylvania that had relevant evidence to this case.
Was there anything here in Philly? Any witnesses, anything?
Not at all, Your Honor, which makes it, distinguishes it from some of the Superior Court cases where perhaps a party is in Philadelphia County, or there's an expert in Philadelphia County, or there's a treating physician in Philadelphia County. All of that is conspicuously absent here. All of that is conspicuously absent.
Counsel, can I just follow up? In Bradick, there was a footnote that really, I think, addresses what's at the heart of this case. And the footnote essentially says the Superior Court presumed that the affiant's testimony would be admissible, relevant, non-cumulative, and necessary. You aren't suggesting that they are not considerations that the trial court has to take into account. You're opposing the notion that there has to be specific affidavits that identify the precise role that each and every witness would play, correct?
I think that's right, Your Honor.
Okay, I mean, because, and you've said it a couple of times, and I mean, the trial court here could certainly intuit that these witnesses, many of them were key witnesses. You could call them key witnesses, you could call them necessary witnesses, but they were at a scene of an accident where the cause was totally unknown and they were investigative officers, et cetera, et cetera. I mean, I think, like the lesson from Bradick, as it's extended, is you have to give the trial court credit to be able to intuit from evidence of record the importance of these witnesses. So you don't disagree with that, do you?
No, Your Honor. No, Your Honor.
That makes sense that it would be beyond that to almost require complete discovery to have to be more specific than that.
And Your Honor, that's why I think I've made reference to Cheeseman on two separate occasions.
Let's hold on just a moment. That's to allow the viewers to know we're in Philadelphia. Or Pittsburgh, or Harrisburg. Please continue.
Your Honor, I think that's probably why I have made reference to Cheeseman already on two separate occasions, and that is that the motion to transfer, I think the case law suggests to us, should be filed at the earliest possible time. And when you have, as we did in this case, we had access to Pennsylvania State Police reports, we had access to NTSB reports, and we filed the petition at the earliest juncture so the parties could know where the case would be litigated, whether it be in Philadelphia County and Westmoreland County, so that when we started the process of deposition discovery in this case, we would know if we were in Westmoreland County or Philadelphia County. And I don't think that, in thinking about this, I don't think that a motion to transfer is supposed to be akin to a motion for summary judgment, where at the end of the case, after you have a fully developed record under Rule 1034, you file a motion with all the affidavit, with all the depositions attached, and you make argument. The idea under Rule 1006, I believe, is to file the petition at the earliest possible juncture when it can be done so in good faith. And I think that the trial court record and order in this case demonstrates the practicalities associated with it.
Honestly, I agree with you 100%. I mean, I think what the Superior Court did here was create an evidentiary burden that this court has never indicated existed in these types of motions. But that's different than saying that the evidence of record doesn't have to support a finding that there are key and necessary witnesses that are located in another forum. I think that's what the trial court found here, correct? Isn't that what Emmer did also? I mean, you know, Emmer really said it's important to identify something that makes the witnesses necessary because their inconvenience is more important than maybe a dozen other witnesses who are really not necessary or they're cumulative. So I think this is just the development of an evidentiary standard that's beyond the realm of anything that this court has done. Do you agree?
I do agree with that, Your Honor. I think that under what the Eimer court did was look at not only the Petty case that I mentioned earlier, which referred to a federal court case and a Third Circuit case and an instruction from the Third Circuit on a dismissal for an interstate transfer. But the Eimer case also looked at, ironically, cited the Boqueto case. And Boqueto is very similar to Reno. It's an air crash that occurred in Portugal. And applied principles that would apply under Section 5322 for a dismissal of a case. And I think that the burden should be higher for dismissal of a case based upon an interstate transfer. We're talking about an intrastate transfer here to a more convenient, a forum that's more convenient to the parties and more important to the more convenient, to the witnesses. And
I don't know, maybe we aren't saying the same thing because I don't look at this actually as a burden of proof issue. I mean, I think what the standard is that there has to be evidence of record not affidavits necessarily, not anything of the evidence of record to support the trial court's decision that the witnesses who are at play in this case are relevant, their testimony is admissible, it's necessary to the adjudication of the case. Actually, it's interesting because that footnote that I referenced that appears in Bradick, actually what the trial court said was, and we recognize that these are key witnesses. So, I mean, I don't think this is a burden of proof. I think however you do it, you have to establish that these are important witnesses. They're key witnesses who are going to be inconvenienced. No?
Well, Your Honor, I think you have to establish that they're witnesses. When, whenever, and we can sometimes, dictionary definitions are helpful, at least to me. So I was looking at the Webster definition of a witness, and it's one who gives evidence and one who has personal knowledge of something. And the cases from this court, I think the Superior Court uses various synonyms to describe what this witness should be. It was critical, key.
We didn't use key. We did not use the word key.
We use necessary.
Correct. So I think that
To that point, well, go ahead and finish your sentence. I'm sorry.
No, Your Honor, what I was simply going to say was that it's very, very, getting back to Chief Justice Todd's point, it's very difficult to know, if not highly improbable to know, at the outset of the case, how material a particular witness might be. The 13 state troopers whose names are listed at reproduced record at 705, what exactly they know in terms of the witness summaries and statements, the measurements, the photographs, those aren't clearly known and will not be known until substantial discovery is completed. So Your Honor, I don't know, maybe we are saying different things. Because
it could be. I mean, because let's say that the witnesses that you listed were the 72 nurses who treated a plaintiff. Okay, are they key witnesses? 72 nurses who, during the course of the hospital stay, came in and out of the room over the course of the 25 days. Would they be key witnesses?
They would. It's very unlikely that they would be.
So we aren't saying. We are saying the same thing. I mean, there's an intuitive nature to what a trial court does in this situation. Yes. Anyone who has ever been on this part of Interstate 76 in Westmoreland County would understand the critical nature of the people who did the investigation on the scene and the accident reconstruction people and those people who took the measurements and things of that nature. And a judge in Westmoreland County is certainly going to have that, and a judge in Philadelphia is certainly going to understand that that truly would not be the case in the other forum. So, I mean, there is an intuitive nature, but I still think that the witnesses have to be more than cumulative informational types of witnesses in a lawsuit.
Yes, I think they certainly need to have relevant evidence, and until deposition discovery is really complete, though, Your Honor, I don't know if you would know that whether they were cumulative or not. I mean, using some of the depositions that were ultimately submitted in this case, one of the paramedics treated 6 of the plaintiffs, one treated 5 of the plaintiffs, one only treated 4 of the plaintiffs. But what is really interesting or compelling about her testimony is she was the one who treated the family of the young lady, the girl, who was missing at the time, and it was ultimately determined she suffered fatal injuries in the accident. So she was with that family in the minutes after this horrible tragedy. And unless and until the record is developed, one will not know how important that testimony may be, how key that testimony may be, whatever adjectives one uses. But I think that what the Superior Court did here and did in Eimer was impose a very, by the way that it described it, in terms of, it even suggests that in the witness affidavits themselves, they should be describing why they're key witnesses or how their testimony can be helpful to the defense. And I think that's rife with problems if you're asking a disinterested witness to provide in an affidavit some affirmation as to why their testimony could be important to one party or another in a case.
Justice Mundy had a question.
I'm glad that I let you continue, because that was exactly my issue with some of the witnesses listed in this case. Seemed like you could comb through a medical record and come up with 30 or 40 witnesses that not necessarily would be called at the trial of this case. And different than Cheeseman and different than Braddock, shouldn't there be some concern that in this case, maybe for the first time before our court, we have a situation where there's about, I think you said 50 injured parties. I didn't count the caption, but there's a substantial amount of parties that are involved as the plaintiffs in this case, and we know that first and foremost, the plaintiff's choice of forum should be given some weight. And so, can you address that?
Certainly, Your Honor.
Please.
There is no question that the law from this court and as applied in the lower courts is that the plaintiff's choice of forum is to be given deference. But it is not absolute. And in this case, as was pointed out by Justice Wecht earlier, there is simply no connection to Philadelphia County. None of the plaintiffs are from Philadelphia County, and none of the witnesses are from Philadelphia County. So while deference should be given, I think that the cases from this court have also said that the FNC doctrine is a necessary counterbalance to ensure fairness and practicality and to guard against a seriously inappropriate forum. And I think under the facts of this case, for an accident that occurred 250 miles from City Hall, that Philadelphia County is a seriously inappropriate forum.
Mr. Dapper, could you explain to me what amount of consideration we should give to the advances in technology and availability of remote testimony?
I am happy to do that.
Oh, I'm sorry. Your other
But
counsel's doing it.
Mr. Palumbo
No, we'll wait for him. I'm sorry.
was planning to address that.
I'll wait for him. Thank you.
Is someone else also going to address the abuse of discretion issue, or is that you?
No, Your Honor, that's certainly, to the extent I have not adequately addressed that, I would like to.
Well, I guess that's my point. The focus, I understand the issue about this key witness language that the Superior Court uses, but you identified virtually every witness, save for the plaintiffs, that are going to be called in this case, right?
We tried to identify
as best as you could early in
all the factual witnesses.
Right. So
non-expert. Yes.
I would assume whether they're all important or some of them are important, we have to agree there are important ones in there, right? Is there any dispute that there are important ones in that list that you came up with?
Your Honor, I don't think so, and I think that that's why it's in particular, I think it's footnote 11 of the Superior Court opinion in this case, where certain excerpts were taken from the depositions of the 9 witnesses who were taken to the effect of, well, I didn't see the accident. I don't think I'm an important witness, something like that. Well, that will ultimately be up to the court to determine at a trial whether someone has relevant and admissible testimony. And I give the example.
I don't believe by the time you get to that point that the judge decides whether a witness is important or not. They decide whether they have relevant and admissible evidence.
Yes, Your Honor, and that's why I gave the example of the one paramedic who wound up treating the family of this young girl who was fatally injured, and she was with that family in the minutes after this accident, who at the time she was missing. And I don't think until you start the deposition discovery process in a mass casualty case, do you know exactly which witnesses will be providing particularly relevant or how relevant the testimony may be.
But I'm trying to figure out where the Superior Court, I think I read the opinion correctly, where the Superior Court said there was an abuse of discretion, was saying that the Superior Court failed to apply this key witness paradigm. Is that the only abuse of discretion that they didn't follow the law. The trial court didn't follow the law. They didn't analyze each witness to determine which ones were key and didn't have the right number of key witnesses. I mean, is that the abuse of discretion that's been identified?
I believe so, Your Honor. I think it obviously needs to be manifestly unreasonable, but here, but also, if there's any proper basis on which to affirm the trial court, that's what should occur under the abuse of discretion standard. And here, Judge Cohen found that the state troopers, the emergency medical providers, the medical providers themselves, the investigators all had relevant evidence on, he listed 8 or 9 specific topics, whether they be the road conditions and the weather conditions and the passenger conditions and so forth. He listed all of those and gave a couple of specific examples of deposition testimony, and I submit that instead of giving the deference that the Superior Court should have under the circumstance, substituted its own judgment and reviewed the record in a way, as advocated by the plaintiffs, that diminished the importance of that testimony and looked at it through a different prism. And I think that standard of review is paramount, so that if, in ruling in this case, I think that, as I said at the outset, I think the clarity to the litigants that Bradick afforded and the discretion to the trial courts that Bradick afforded was the right balance. And I think that it was not, while it may have been, I'm sure, looking at the 1987 decision in Petty or looking at the 2009 decision in Bocato, I mean, the language that the Superior Court cites on Eimer in this case, it exists, but it exists from a completely different context and a completely different standard and a completely different issue, which is a 5322 dismissal, and it involves principles that this court specifically disavowed in Cheeseman, that is the public interest factors.
Yeah. All right, I think we've got it. Thank you. Let's hear from Mr. Columbus.
Thank you.
Good afternoon, Your Honors. May it please the Court, Robert Columbus on behalf of Penske. And Your Honors, I'm here to address the plaintiff's argument that modern communication technology makes the forum nonconvenience doctrine questionable as a whole. Plaintiff, in their brief, have asked the court to reconsider the application of the doctrine and evolve the factors based on this communications practice. The first point that I'd make on this, Your Honors, is that it is not the question that's before the court. What this court accepted for review was the specific question of whether the Superior Court misapplied the doctrine by adding a key witness requirement.
Isn't it subsumed, though, in the question?
I don't think it's subsumed to the extent that what plaintiff is asking for is a complete revision to the forum nonconvenience factors, which is what I understand to be in plaintiff's brief. To the extent that the question is what Your Honor asked, which I think is a good question, what is the role of communication technology in the analysis? That certainly is subsumed. I agree with that. So I'm specifically addressing, the court can see
So the way I phrased it is okay.
The way you phrased it is right. On page 18 of the plaintiff's brief, I see them to be suggesting something very different.
I see.
Which is that the court should revise and reconsider the whole doctrine, given that today anybody can testify live by remote video. And I would respectfully suggest that does not justify reconsidering the doctrine. First of all, it's not before the court. That issue was not preserved below, wasn't raised in opposition to the forum nonconvenience motion, and so therefore the trial judge in the Superior Court did not exercise any discretion around that question. But on the merits itself, this court has repeatedly expressed a strong preference for live, in-person testimony at a trial. That's what a trial is. And to the extent that the availability of remote video technology is a new thing, new technology, it doesn't change the very nature of a trial. This court went back to in-person trials in 2021 for a reason.
Well, and it also kind of removes the discretion from the trial lawyers as to how to try their case.
Exactly right. That's fundamentally, there's an unfairness here because
On both sides, yeah.
The state of play here is that while we may not be able to identify specifically which witnesses will come from Westmoreland, we know that all of the eyewitnesses, any of the important witnesses will be there. And so the defendants are in a position where they need to either drag these witnesses to Philadelphia, whichever ones they end up being, or choose to present them remotely, live, or by video deposition. And none of those is a fair choice to put on just one side of the case. And it's all the result of the plaintiff's choice of forum. So it's an unfair and oppressive choice, and that's why the trial judge can consider in the mix of factors that Braddock sets forth and in the mix that has already been discussed by Mr. Dapper, it can consider the technology, and I could even imagine a situation where the court said, okay, there's one witness, that witness has some relevant testimony and they may need to testify remotely, but that won't be burdensome. But in a situation like this where every single potentially key witness, every eyewitness to the crash is remote, the court is well within its discretion to do what Judge Cohen did, which is to say that it would be oppressive to keep the case in Philadelphia. Thank you very much, Your Honors.
Thank you. Yes. Oh, do you want to do it now or after?
Stuart, before you begin, I want to thank you for your giving your time so generously to the seminar this afternoon on involving young lawyers in oral argument and how they can make themselves available for that. And I think we have in our audience some of the young lawyers who are attending the Pennsylvania Defense Institute seminar this afternoon, so they can hear you in action and then hold you to it later on this afternoon. But thank you for your generosity in giving your time to that.
Well, thank you very much, Justice Donahue. It's an honor and a privilege to be here. Maybe it's a little bit more pressure. I'll do the very best I can today. I get the honor of going last, and we'll see what we can do with that position. I just want to comment on a few things. I thought it was interesting, Justice Probson, when you brought up the standard of review, and that's initially what was I going to comment on right off the bat. Many years in my legal career, I had the honor of clerking with two appellate judges, Robert Byer and Rochelle Friedman. And while that was many years ago, the first thing that I was taught as a brand new greenhorn lawyer was that the standard of review was where you started your journey. And in this case, the Superior Court did that when they reviewed Judge Cohen's decision. They cited it right off the bat. Then they turned around and, in my opinion, did a deep dive of the affidavits. They criticized the affidavits. They basically decided not to reference other material that Judge Cohen took to review, including the reports of the National Traffic Safety Board information, which provided a plethora of information to allow him to make a decision based on the totality of the circumstances. Then they, in our opinion, and I would suggest, they substituted their judgment and conclusions for the trial judge, and they basically reversed the decision. If this was not a de novo review of the evidence, I don't know what was. In our opinion, Justice Cohen reviewed all of that, used his common sense, and decided that this case should be transferred to Westmoreland. Conversely, if he would have done that same drill and he would have decided that this case remained in Philadelphia, I think it would be hypocritical for us to turn around and say, well, there you go, he abused his discretion, even though he looked at the exact same information. I think it's a very important standard, which was taught to me by those two fine jurists, and I would suggest that that's exactly what the Superior Court did.
Well, that's interesting. Are you saying that regardless of what Judge Cohen had determined, you would have opined that the Superior Court would necessarily ratify that? I mean, no. I would have thought you would have argued that had Judge Cohen here in Philadelphia ordered the case to stay in Philly, that you would have felt that was an abuse of discretion, given the witnesses and everything in Westmoreland.
No, personally, Your Honor, obviously our clients as the defendants, we would be sorry that we lost, but I think we have to honor and look at what the standard of review of that trial judge would be if we were to appeal that decision. And that's what I find troubling, is the fact that he did a very thorough job. He set it forth in his opinion, and yet the Superior Court turned around and, quite frankly, in our opinion, and we would suggest it is a de novo review of that, which we do not think was appropriate.
I mean, I just found that concession curious, because I'd be surprised that you seem to suggest that discretion could not be abused.
No, I think absolutely discretion can be abused depending on what is set forth in the opinion by the trial judge. If the trial judge turns around and admits that they didn't review much of anything, I think when you look at that record, then the Superior Court would be able to say that he or she did not do this or he or she did not. I think the decision that was set forth by Judge Cohen adequately sets forth everything that he did.
Justice Robson, let's hold off just a moment.
The only way I understand it that the Superior Court was able to get to abuse of discretion was by suggesting that, or not even suggesting, holding that the trial judge committed an error of law. Somehow didn't apply the right, I mean, the minute you start putting guardrails on abuse of discretion, it's no longer an abuse of discretion, but somehow, some way that there's this legal doctrine of key witness on top of the fact that the affidavit of the key witness has to start with, I am a key witness. I mean, it just seems that was, and the Superior Court sort of made that conclusion and then jumped off from there and said, okay, so he made a mistake, this is how we should have ruled, and that's why we're reversing. Is that my understanding of how they did it?
That's our understanding as well. I mean, quite frankly, we were rather surprised when this key witness element was now put to the forefront of determining whether a case should be transferred.
And I think you're only saying is if they would have followed abuse of discretion, that straight abuse of discretion, you think that Judge Cohen maybe could have reached a contrary conclusion and it would have gone up on a pure abuse of discretion standard and he would have gotten the benefit of the doubt on an abuse of discretion side of things. There would have to be shown manifest, all those things. You're not necessarily saying you would agree with it, but you just want an even playing field in a standard that is an abuse of discretion, which is highly deferential.
Absolutely, it's highly deferential, and that's why I think the standard is there to pretty much, I'm not going to say protect the trial judges, but to give them the authority and the ability to use their experience when they make these kinds of decisions. And
go ahead.
So another point that I'd like to talk about very, very briefly is the case law refers to the convenience of the parties and the witnesses. And I think sometimes when we start to talk about these cases and the parties and who the witnesses are, and here we have the issue of the key witness, I would suggest that who protects the convenience of the respective witnesses? It's not the lawyers, because they're more interested in their parties and defending their position. It frankly is the trial judge. And I think that's why there should be more authority given to the trial judge to take a look at who these potential witnesses may be and what they might know, and that he or she should be able to use their common sense in determining that. And an example of that, Your Honors, are the first responders to these cases. And in many times in these kinds of accidents, we're really only talking about one state trooper, maybe one or two EMS personnel, so it's not really that big of a deal. In this case, I would suggest that just about every state trooper within many, many miles of this terrible event, as well as just about every EMS, voluntary fire department official and so forth, were there for an extended period of time. And discussion in the briefs was brought up about how, well, it's not that big of a deal to have a state trooper drive to a distant forum to give testimony at a trial. Well, if they were like a typical fact witness, that's probably true. But the first responders, don't forget, have a very important role in their respective counties. The fact of requiring them to drive a great distance to a distant forum degrades the safety, the response time, the lessens the availability of manpower and the ability for them to do their jobs in that particular county. And so if we have a number of them that are scheduled to be far away, and God forbid something else was to happen, that would not be appropriate for that particular county. And I think that's one reason why when there's a large amount of first responders involved, further deference should be given to that factor in considering what county is appropriate. The last issue that I'd like to raise is one that is related to some of the issues that were discussed by my brothers. And when we look at these cases, many of them relate to cases involving Philadelphia, and that's all well and good. But we would suggest, Your Honors, that this is not a Philly thing. This is a Commonwealth of Pennsylvania thing. And quite frankly, there's 67 counties in our Commonwealth that have respective trial judges that deserve a better way and a more efficient way to decide these types of cases and decide what is necessary for a case to be, whether it should be in Pike County or Bradford County or Erie County, depending on where else it might have taken place and where all the witnesses might be. We would respectfully request that you not only affirm the trial judge and reverse the Superior Court, but maybe possibly clarify the Braddock decision and the standards set forth there so that we'll have a better understanding in the future so we can avoid what has happened in this case. This terrible situation happened more than 5 years ago. 5 years ago. We're still in the first inning of the litigation.
Counsel, how do you suggest we do that?
I'm sorry.
Over here.
Oh, sorry.
How you
Sorry,
doing?
Justice McCaffrey.
How do you suggest we do that? 'Cause
Well,
one of the issues that always comes up in my mind is, having practiced for as long as I did, is these motions for transfer of venue usually occur at the outset of the case, and you don't know who you're going to call until you actually go through the discovery process and witnesses. I mean, my thought process has always been the same, which is maybe we should just kind of delay the motion practice for change of venue on a forum nonconvenience argument until we actually finish discovery and figure out who we're going to call, because I know what the plaintiff's argument is going to be in this particular case, which is you've identified 72 witnesses, but when we get down to trial, you're only going to call an accident reconstructionist and maybe one fact witness. So how do we sit here and say to the trial judges or implement some kind of standard to the trial judges that what they should look at on a motion to transfer venue at what amounts to a preliminary objections standpoint? I mean, early in the process, before we know who the witnesses are, what, if any, relevance their testimony has to the case, and whether or not they're going to be called.
No, and that's a very valid point, Justice McCaffrey. But, well, I think there's one issue where when you commented that maybe we should wait till later in the case. Unfortunately, we have done that in cases where we've done substantive discovery, and quite frankly, our focus was on trying to resolve the case maybe, and it didn't resolve, and we said, oh boy, maybe we need to file a motion to transfer, and we were told, quite frankly, you did all the substantive discovery already in this particular forum, and you frankly, in the view of the trial judge.
That's a bit of a misnomer. And,
well,
and the reason I say that is because we've actually talked about that issue. I mean, the parties are going to be deposed wherever you say they're going to be deposed. Having practiced law, I'm sure you guys have practiced law for longer than I ever did, probably better than I ever did, but if you've got a fact witness, you're going to go to where the fact witness is. You're not going to drag a fact witness from Westmoreland County to a deposition in Philadelphia County, are you?
Well, no, that may be true. However, when the trial takes place, the fact witness should not have to be able to have to travel to a distant forum in order to appear at the trial.
Yeah, but that's inevitable. What if you've got 15 fact witnesses all from different counties and different parts of the state? You're going to have to drag them, 14 of them, to some forum that's inconvenient, so one of them's not going to be inconvenienced. It's always a possibility.
It is a possibility, and I think it depends on the particular facts of the case.
But that's my point. Why don't
in
you
this
wait till
case,
later on in the
though,
process?
in this case, all of the witnesses are from those 3 counties right around there, especially the first responders, They're all right there.
So what does that have to do with forum nonconvenience? If you're taking their depositions in Westmoreland County?
That suggests the fact in a case especially like this with those particular facts that we're in the county that makes it the least inconvenient.
Most convenient.
Yeah, most convenient for those particular individuals.
Counsel, isn't part of right here? Isn't part of these cases have to stand on their own facts and their own totality of the circumstances?
Absolutely, and that's where.
And I think that's part of the problem that I'm struggling with your suggestion that we clarify the rule. I think our rule is pretty clear. I mean, there has to be evidence of record to support the trial court's decision that the forum is inconvenient. and the trial court writes an opinion like this trial court did, which was an excellent opinion, frankly, establishing that the witnesses were key witnesses. I know you guys don't like the word, but I mean, there's no way you could read that trial court's decision without coming to the conclusion that he determined that in any trial of this matter, these witnesses or some subset of them were going to be key to the liability portion of the case, just given the circumstances of the accident. So I'm not sure how much clearer we could make it. I mean, you have a trial court who writes a good decision that takes into account all of the evidence of record and the totality of the circumstances and comes to a reasoned conclusion. What else do you want us to tell them to do?
I would suggest that maybe there's a little bit more clarity. I mean, right now there's points about a great deference on the plaintiff's choice of forum, and that's all well and good. But I think you might want to also take a look at the deference should be maybe affected if the plaintiff has nothing to do with that particular forum.
Why?
Why?
That's
because
the
quite
plaintiff's
frankly,
choice of forum. They can bring in an action in any of the designated counties. That's what makes it a plaintiff's choice of forum. There are some situations where it doesn't matter. Don't you agree?
I agree. In some
well,
situations,
that's why
it
you
doesn't
have
matter.
a plaintiff's choice of forum.
Right, but there's also cases where I think there should be more of a balance where it absolutely affects and inconveniences a number of the witnesses, especially in a case like
Well,
this.
that may be a tacit consideration that a judge might consider in a case where there are all these witnesses hundreds of miles away in a case, and the only connection that the case has to the current venue, which is otherwise inconvenient, is it just happens to be the plaintiff's choice of forum. That's forum nonconvenience. I mean, that's, to Justice Donohue's point, I'm not, you know, I think I don't understand too what else you're asking for, but I'm not sure you need to.
Like, for example, nobody complained about the cases that were brought in Allegheny County, right?
Well, I think it would depend. I mean, maybe
In this case.
Oh,
the
in this case,
cases
no.
were filed
no.
in Allegheny County. The cases stayed in Allegheny County. Unfortunately, it doesn't appear like anything has happened in any of these cases for reasons that are unclear to me. But
Well, they're all stayed.
I agree that you're complicating and perhaps undermining your own case. I mean, Braddock is very clear. What's not clear is the Superior Court's opinion here.
that's right.
I will agree with that.
So I don't know why you insist on overcomplicating this.
Well, I just think that and I would just suggest that, and I'm sorry if I did that, but I just think that the ability of the trial judges to utilize the totality of their circumstances and their common sense to look at the overall record to make a decision should be supported.
Okay,
Thank you very much for your time.
Let us hear from Attorney Senoff for the appellees. And Mr. Senoff, you should feel flattered by the fact that we had 3 attorneys. It took 3 attorneys to counter your arguments that you're making all by yourself.
And a camera case before yours. He's a camera expert, everybody.
Chief Justice Todd, I don't know if I feel flattered by that, but I certainly feel something given the number of forces arrayed against
But not
me.
intimidated.
Certainly not that, no. Chief Justice Todd, and may it please the court, David Senoff for appellees. In the movie The Matrix, at the very beginning of the movie, the main character is given a choice between taking a blue pill or a red pill. If the character takes the blue pill, he's going to live in a world that's not real. If he takes the red pill, he's going to learn the truth, even if he doesn't like it. And I will suggest to you that forum nonconvenience is one of the few blue pill, red pills questions or choices left in Pennsylvania law. And what I mean by that is that the defendants always try and convince, or the moving party always tries to convince the trial judge to take the blue pill, to live in this altered reality where 66 first responders from 3 different counties are all going to be called to trial in a case where all of the plaintiffs are passengers and there is no liability issue to be decided except as between the defendants. The plaintiffs, on the other hand, always try and convince the trial court to take the red pill and go live in a world that's much less nice than if you take the blue pill. But I suggest to you that we would rather live in that world for the following reason. What it seems to me has been occurring is that, and the reason, and this culminated in the court's, I think, Emmer decision, perhaps the Superior Court's Emmer decision, perhaps the Ritchie decision before that, is that the defendants have reduced forum nonconvenience transfer motions to some kind of formula. And what I mean by that is, if they have enough evidence in the form of affidavits, depositions, whatever the case may be, they put that in the record, but they list every potential witness. So they pile up 66 affidavits.
But Mr. Senoff, if this was a case where there was any evidence that the defendants were larding the record with cockamamie, concocted evidence, that would be one thing. But tell us what there was by way of evidence that wasn't Westmoreland County evidence. The first responders, the coroners, people, the police. This was all, three of us drove over the mountains yesterday from Pittsburgh, and we passed this site, as we do often. And it's definitely quite a bit more remote than Dauphin, which this court unanimously said was too remote from Philly in Braddock. So if Dauphin was too remote in Braddock, in a case with fewer Dauphin witnesses than Westmoreland witnesses here, how can you say that this case is a horse of a different color, whether red or blue?
Because I suggest that it's a horse of a different color because the witness, it's a false choice. In other words, the number of witnesses and the fact that they're all from Westmoreland is irrelevant in this particular case on these facts because unlike Emmer, where the parties were arguing about whether or not a site view was necessary because of how the roadway was or whether witnesses, the accident reconstructionist from the Pennsylvania State Police was important to determine the position of the sun and vis-a-vis the view. None of that is important in this case because the plaintiffs are all passengers in a car. So the fact that there's going to be first responders that, as they've said, are going to testify about where the cars were positioned and presumably the Westmoreland County Deputy Coroner was going to testify about where people's bodies were scattered. Of course, he's now deceased, so he won't be testifying regardless because he has met the ultimate inconvenience in testifying. But I think the important lesson from Emmer and then subsequently in this case is that the Superior Court laid out a methodology by which lawyers and trial judges can review the evidence in whatever form.
Counsel, let's follow that question. So the question that was granted is did the Superior Court abuse its discretion, and if so, how? The answer from the opposition is that the text of 10061 nor this court's precedent requires a key witness. This key witness is a manifestation or creation of Superior Court. How is it that that's not an abuse of discretion because they've not only substituted their judgment, but they've added to things that don't exist? To me, that's the important question. So share with me how their addition of key witness requirement is not a substitution / abuse of discretion.
Well, I'll say this. First of all, this is not the first case that the Superior Court has handed down using that term. However, there are synonyms for that term that appear in both their cases and this court's cases, right? They talk about critical, relevant, necessary. And the other thing is that the trial court in this case said the only burden the appellees needed to overcome was to clearly specify the key witnesses to be called and must make a general statement on what their testimony will cover, which they have done in this matter. That's the trial court's 1925B opinion in every single one of these appeals. And so the trial court itself, the trial court availed itself of a key witness.
Well, then how did this, now I'm really confused. If the trial court
followed the Superior Court's paradigm and adopted this key witness standard and made a conclusion, I think Justice Donahue said earlier, that these witnesses, at least some of them, maybe not all of them, but at least some of them, are key witnesses that satisfy this test. How in the world, under an abuse of discretion standard, could the Superior Court have reversed that?
Because in the Superior Court's opinion, they say, although the trial court opined that appellees have specifically demonstrated that the first responders and other named witnesses would provide relevant evidence, the court did not find that appellees had demonstrated that this relevant evidence was critical to their defense.
Well, but the trial court said that these witnesses were key.
Well, the trial court said that.
What was manifestly unreasonable about the trial court's review of the evidence?
Because most of the affidavits, if not all of them, do not contain the type of evidence that was in Bradick, which was cumulative, not right out of the Bradick trial court opinion, right? Potentially inadmissible, cumulative, not necessarily relevant to the issues in the case.
But there was nothing here. Everything was there. This talismanic use of the term key, which comes from the Superior Court, is one thing. But the other thing is, in this case, there's nothing on the other side of the pan. There's nothing here. Everything is there. And it's a motor vehicle catastrophe, so I'm not following your argument that the site is irrelevant, that a view of the site is out of the question, that the testimony of people emergency responders who came to the scene that night is irrelevant. There's a curve there. We drive by it all the time. And to say it's irrelevant is a hard...
When I say it's irrelevant, I mean that it's irrelevant to these particular plaintiffs because these plaintiffs, again, were passengers. There's no doubt that
Counsel, the defendants have a right to prove liability inter se. I mean, this isn't just for the plaintiff.
That's true.
So, I mean, you have to talk about the totality of the circumstances. This is a trial for all. I mean, this isn't a trial on damages.
I agree, and I do think that when you say there's nothing on the other side, what's on the other side is the idea that the plaintiff is entitled to pick his or her venue at the commencement of the case. And what Emmer did was it took an amorphous, or not an amorphous, but a group of cases that all had discussed how the trial court should view the totality of the circumstances and distilled it and said, look, you have to do two things to be successful. You have to identify the allegedly encumbered witness, and you have to make a general statement of what testimony that witness will provide, and the general statement must establish that the witness possesses testimony that is relevant and necessary to the defense.
But it seems like the Superior Court seemed to be straining to manufacture almost like a pretrial statement requirement, the kind of thing that would be required on the eve of trial rather than at this threshold motion stage. And that's not, I mean, Braddock is a brief, concise opinion and includes the words, as between Philadelphia and counties 100 miles away, simple inconvenience fades in the mirror, and we near oppressiveness with every milepost of the Turnpike and Schuylkill Expressway. So that here, 250 miles here, it makes me wonder if this is not forum nonconvenience, what would be Wayne County to Greene County? What if this is not a poster child for forum nonconvenience? I'm wondering what would be.
Well, the reason why it's not a poster child for forum nonconvenience is the characteristics of the witnesses that are allegedly encumbered. So, for example, if the witnesses that were encumbered were the drivers, the defendant, the defendant drivers. And if in addition to that, or perhaps not the defendant drivers, but eyewitnesses, right? Because if they were the defendants, there would be a different requirement to prove vexatiousness. But if there were eyewitnesses to this accident, right, and they could all say with some kind of certainty how the accident happened. I saw this bus going this way, it started sliding. None of these witnesses are going to testify to that. Then I would say, yes, that's a situation where for sure forum nonconvenience applies. But the situation that we have now in the trial courts and in the superior courts is that the defendants try and pile up as much as they can.
Well, there's nothing wrong with that.
I don't disagree.
I mean, and this is like the second time you said that.
I don't.
You have you have the upper hand here. You represent the plaintiffs. And the way our rules work, the plaintiffs get the choice of forum. We've already said that, and there's much difference. You have the upper hand. I don't fault them for piling on evidence. I mean, I think they would probably be committing malpractice if they didn't throw the kitchen sink at this. The question is there anything in the kitchen sink to support the trial judge's decision here? Not how, just because they threw a lot at you doesn't mean that they've missed the mark.
I'm not suggesting that I'm not saying that there's a lot of evidence here.
So are you telling me that none
is,
of the witnesses that they have identified would meet your definition of a key witness?
Perhaps 3 or 4. You know, a first responder.
So if they would have come with
coroner,
3 and 4, would you have argued, well, that's not enough. You need 10 or 12.
No, because it's the quality, not the quantity of
Okay, so they have 3 or 4. Why isn't that enough?
Because in this case, I don't believe the quality of the evidence meets the standard, and therefore we have a very large quantity of evidence. I don't think even the defendants would like a rule that says you can never have one witness affidavit, even if that witness was the most important witness in the case, and have forum nonconvenience. Instead, you have to pile up 50. They don't want that rule because they want to be able to say, look, we have really one key witness, and that guy lives in Westmoreland County, or that woman doctor treated the person in Westmoreland County and has such a busy medical practice that she can't travel to Philadelphia.
Well, counsel, what's wrong with the quality of the evidence?
Well, I think as the Superior Court said in their opinion, the trial court, while they said that the witnesses would provide relevant evidence, upon review of what the trial court said was relevant evidence, the Superior Court found that it did not, and that...
How is that not substituting their judgment for the trial court? How is that, that's where I'm, the question is not what the Superior Court said. The question is, how did the trial court abuse their discretion? That's really the question.
And so the link is this key witness issue, right? The trial court itself used the phrase key witness.
But the reason that's so puzzling in this case, if you want to use the word key, critical, whatever,
necessary.
Talismanic totem words, but regardless, in this case, everybody was out there. This case has as much connection to Philly as it does to China, or China to Philly, because there's one plaintiff here out of 29 and one plaintiff in China, and then there's 27 from elsewhere. So, China or Philadelphia. But so you got everything else in this case is out there, and I just come back to my proposition that if you prevail in this case, I don't think there's anything left of forum nonconvenience in the Commonwealth of Pennsylvania, because I don't see any case prevailing for forum nonconvenience if the plaintiffs prevail in this case, because I don't, as I read the Superior Court's opinion again and again, and it strikes me as really, really straining to come up with this distinction between key and non-key, or
or what have you. I should make it a question mark at the end.
So, Mr. Justice Wecht, I was here for most of the day, so I understand.
I didn't have to say it again, did I? That wasn't a question.
You understood that before.
What I'll say is this: first of all, the connection to the county was litigated in preliminary objections based on improper venue, and the same trial court overruled those objections. So now we're here on a motion to transfer, and on a motion to transfer, we're not talking about necessarily the connection to the county, we're talking about the convenience of these allegedly encumbered witnesses. And I will say that the quality of, so to answer your question, Justice Brobson, how did the trial court abuse its discretion? It abused its discretion because it found in these affidavits relevant, critical, non-cumulative, necessary testimony, which we believe, and the Superior Court found, was not the way the trial court characterized it. The trial court said that.
But that's substituting judgment.
Not if the law requires that the trial court identify, and I'm not going to use the phrase key witnesses, but that the trial court review the evidence and determine that the witness's information, however presented, is relevant, non-cumulative, admissible.
Well, so was it a procedural error then, that the trial court just didn't say enough, or was it a substantive error that the trial court said X, but the facts in the record don't support it?
I think it's a substantive error. I don't think it's an error in the way the trial court wrote the opinion. I think the trial court could not have, given what's in the record, the trial court could not have written an opinion differently, and I think that was what...
Saying there's no... okay, so this is I think I understand your argument then. Your point is, trial court abused its discretion because there's not a scintilla of evidence in the record to support the conclusions or findings that any one of these 30-some witnesses is key.
Well, I don't know if I'd say scintilla, but I would say...
Well, scintilla is all that's necessary. If there's facts in the record to support the trial court's findings, then it's not an abuse of discretion.
Well, I don't think that the evidence that was presented rises to the level of producing a scintilla of evidence, and I don't think the Superior Court did either.
The question is, does your disagreement and the Superior Court's disagreement, and even my disagreement, matter?
Yes, I think it does, depending on how the law is formulated, right? In other words, if in filing a motion to transfer, you can simply list from A to Z every first responder that was on the scene, regardless of what they did or whether they saw anything or they just operated ambulances, and that's enough.
But that's a red herring. That's not what happened here. There's depositions, there's affidavits, and as Justice Brobson said, had they not been as thorough, had they not produced 11 depots, affidavits, whatever it was, then wouldn't you be arguing that they didn't submit enough?
Not necessarily. I mean, the argument is on the quality, not the quantity of the evidence.
Keep saying that, counsel, and that's where I'm just challenged by that distinction that you're making. Let's say that they identified 5 witnesses, and all 5 witnesses were at the scene of the accident on the night of the accident. They used their perceptions, their measurements, their investigation at that time in reconstructing how the accident took place, period. That there are only 5 witnesses. And there's no question that those 5 witnesses are located within 50 miles of Greensburg Courthouse in Westmoreland County. Why wouldn't the trial court be correct in saying, under those circumstances, the appropriate forum for this case is Westmoreland County?
presuming that those witnesses can state what their hardship is, right? In other words, what's their...
Not that they state it, but it's otherwise evidenced in the record by some other means, photographs or, things of that nature. If the trial court made that conclusion, these are the 5 witnesses who are going to put together the story about how this accident happened. They're all within 50 miles of the courthouse in Westmoreland County. That's a transfer of the venue, is it not?
Yes,
So
I
how
totally
is this
agree with you.
Well, how is that
Because-
case different from, how is what I just said different than this, other than there were more witnesses that were identified?
Because those witnesses don't say what Justice Donahue,
But they
you
didn't have
said.
to- But they didn't have to say it. If the judge, using his or her intuition, can determine from the record that that is indeed what these witnesses are going to provide in this case.
I don't disagree with that, but I do disagree with that characterization of the evidence that was of record in this case when the trial judge reviewed it.
Could we get back to just the importance of the deference to the plaintiff's choice of forum? I mean, traditionally, we've said we're not going to overturn that unless we have weighty reasons to do so. Question mark.
So yes, obviously, we've said that in our papers, and that is something that we agree with. We don't believe that a weighty reason is proven based on the distance from the courthouse to the home of the witness. I don't think that's ever been the law in Pennsylvania, that distance alone is sufficient to prove that that's a weighty enough reason. And that was the reason why in our brief we discussed advanced communication technology, not because we want to do away with forum nonconvenience, but because of the idea that if you just use distance as a factor, if that's the sole factor, then the idea of advanced technology makes the world smaller.
What's the limiting principle there? I mean, if we bite on that, then it seems to me there's no such thing as an oppressive forum then, right? If the answer to a forum nonconvenience motion is always going to be, well, just zoom in, right? Forget the jury demeanor issue, live witness features, et cetera, just zoom in. I'm not sure how far your argument goes there, forcing the defendant to that choice.
My point is not that the defendant should be put to that choice. My point is that the doctrine has evolved over time. And what was once considered inconvenient is maybe not necessarily inconvenient now. And so the evolution of the doctrine is done by case law, right? Unless this court, with the Rules Committee, rewrites the rule. But we're not suggesting that advanced communication should be the end-all and be-all, because obviously the defendants have the right to use and call whatever witnesses they want live, and forum nonconvenience is premised on making the trial or the obtaining of evidence easier, more convenient. But the question remains whether or not you need ambulance drivers who may or may not have any other pertinent evidence other than they drove the ambulance, whether that is sufficient to rise to, that you say that you're going to call those witnesses, but then you don't, or they could appear by Zoom.
They can't get them. Maybe they can't get them to come all the way to Philly. Maybe they could only get them in Greensburg.
Well, and then, so my response to that would be the advanced communication.
Well,
Mr. Senoff, one
we've had
point-
ACT, Mr. Senoff, in Pennsylvania for 25 years. I mean, we've been doing video depositions, and but you're asking us to basically say ACT may be an alternative to remedy witness inconvenience, which is part of the consideration for forum nonconvenience, which means, according to what Justice Sweck is saying, witness convenience ends being a part of a forum nonconvenience criteria if we adopt the ACT paradigm that you're suggesting.
All I'm suggesting about ACT is that it's another tool in a toolbox for the trial court to consider, for counsel to consider. You know, ACT in terms of testimony in court has been around for probably as long as there's been video cameras, right? But it certainly is something to be considered when you're talking about witnesses who may or may not be central to the case.
Mr.
I'm going to use the
Senoff,
word central.
one of the points that your opposing counsel for the appellants made that seemed somewhat persuasive to me is that so many of these witnesses are first responders, and they're in a county where we have a number of first responders who are absolutely needed to service that county. So pulling them, I don't know how many would ultimately be pulled, but pulling them out of their county to go testify in Philadelphia has a detrimental effect on the service provided in Westmoreland County. Could you comment on that?
Yeah, I mean, first of all, I'll just say I'm not sure that was raised, but rather than making a waiver argument to respond substantively, I would say that any trial, even in Westmoreland County, is going to require the absence of some of these first responders. Now, granted, the absence will not be for as long a period of time, but again, I'm not certain, based on the evidence in this record, that every single one of those first responders would be called at trial.
Well, nobody's certain.
Well,
I mean, it's an early determination at the beginning of the case.
Let me
we don't know what you're going to stipulate to. We don't know what they're going to stipulate to. We don't know what. It's the best you get at the time you make the motion early in the case.
Let me say this. I'm not saying whether it's certain that they're going to be called. I'm not. I think it's unlikely they'd all be called. But even taking that out of the equation, I think that the defendants would be hard-pressed in this case to establish that calling all of these first responders wasn't cumulative. Having been in the lower court, having tried cases like this, I think, you know, this number of first responders, the idea that they would require every single one of them to appear, and a trial court would rule that it's not cumulative.
What if they only call 5 of them?
Well, I don't know then if they only call 5 what the effect is on public safety to.
Well, much bigger than it would be in the city of Philadelphia, where you have thousands of first responders, than in Westmoreland County when you have a couple dozen.
No doubt. I mean, just the numbers alone support that. But I do think that the problem here that we have now, that everybody is seeking a remedy for, is that the application of the doctrine by different trial courts is different. And some of the trial courts will say, oh, you know, you gave me 11 affidavits, that's great, thank you very much. Some of the trial courts will say, you gave me 11 affidavits, but they're all really not worth the paper they're written on, so I don't think the evidence supports.
Well, that's the beauty of abuse of discretion, is 2 judges can look at the same stuff and reach a different conclusion.
Well, I understand that, but the problem is that in order to maintain a workable standard for practitioners and for the trial judges, there has to be at least, if not a test of the evidence, but at least a procedure.
Well, hasn't Bradick and Cheeseman done that?
I don't think so. I think what they've done is
What do you suggest that we should say that Bradick and Cheeseman did?
I'm sorry?
What do you suggest that we should say that Bradick and Cheeseman didn't?
Bradick, first of all, Cheeseman eliminated for sure the consideration of public factors from this entire debate. So that's number one. Number two, Cheeseman said, we don't really care what the form of evidence is, right? We're not going to require affidavits. That's up to you. And that's fine. And I think Bradick reaffirmed Cheeseman without question on those issues, and then said, you know, we're not going to, and then interposed what I'll call the totality of what the Superior Court has called the totality of the circumstances test, because it was in Bradick where you can first see that this court said that the trial courts were, that they criticized the Superior Court because they reviewed the individual witness testimony and affidavits in such minute detail on an individual basis.
Right, we
was
reaffirmed the
ridiculous.
deferential standard we were given the trial court, which is why we then told the Superior Court, when I was on the Superior Court, that they should give great deference to them under an abuse of discretion standard. So I think we're kind of, the arguments are getting circular at this point.
I understand that, but I do think that the idea that the Superior Court in Emmer had created this sort of...
You were on Emmer and I was on Emmer. I was actually on the panel with Judge DeBow and Judge McLaughlin in that particular case, and I didn't want to steal counsel's thunder. But the issue in that case was there was two witnesses. The one argument was that we could get better access to the medical records, which was kind of soundly rejected. And the second one was a state trooper may be called as a witness, and then there was the recognition or a stipulation later on down the road that the state trooper's testimony would form the basis for the accident reconstructionist. So therefore, I think we used the words, I think Judge DeBow used the words key witnesses, but it was really a recognition that neither one of those justifications were really relevant.
Right, and there was also the issue of the jury view and all that. But I will say that I think the identification of a test where first you identify the witness that's got a problem, right? I mean, at a minimum, that has to happen. And then you identify the information that the witness is going to provide. Now, the Superior Court in this case did not fault the trial court or the parties, I guess, for not putting that in their affidavits, but did say that there was an absence in the parties' papers of information that would help the trial court to determine whether or not these witnesses who were encumbered also had relevant critical information to provide at trial. And so I don't think that in and of itself is a bad lens to view how to approach these cases. I'm not suggesting that there should be some statement about the quantum of evidence or even the, some standard of proof. That's not what we're here talking about. What we're here talking about is whether there is a logical, reasonable way to start to approach these cases that is uniform so that it can be applied by all practitioners and all trial courts.
Thank you, Mr. Seneff. Are there any other questions? These were outstanding arguments by all counsel. We appreciate it very much, and we have a lot of thinking to do, and that's what we're here for. Thank you.
Thank you all.
Mr. Minner, we're going to take a quick 10-minute recess, and then we'll hear the last case.
Good luck, Mr. Stewart.
Well, we're clearing the courtroom. Just a few people left in one case. Would you call the last case, Mr. Minner?
Commonwealth of Pennsylvania versus Anthony Lewis, representing Mr. Lewis, Mr. Daniel Alvarez, representing the Commonwealth, Mr. Stephen Wilder.
Good afternoon. In this discretionary appeal, 2 police officers were on routine patrol in a known high-crime area. Upon seeing the officers, appellant fled. One of the officers pursued appellant on foot and ultimately apprehended him. The officer also recovered a bag containing a firearm, which appellant had discarded during the chase. As a result, appellant was charged with various firearms offenses. Prior to trial, appellant filed a motion to suppress the evidence, asserting that the officers lacked reasonable suspicion to pursue him and that his abandonment of the bag containing the firearm was therefore not voluntary, and thus that evidence of the firearm should be excluded. The trial court denied the motion to suppress, and the Superior Court affirmed, concluding that unprovoked flight in a high-crime area was sufficient to establish reasonable suspicion to detain appellant. We granted allowance of appeal to determine whether the officers had reasonable suspicion to detain appellant, and more specifically, to consider whether the high crime area factor is a relevant consideration in a reasonable suspicion analysis. Please proceed.
Madam Chief Justice, and may it please the court,
Could you speak up, please?
Madam Chief Justice, and may it please the court, I'm Daniel Anthony Alvarez, and I represent the appellant, Anthony Carlton Lewis. The evidence offered by the Commonwealth through the bare bones testimony of police officers was not sufficient to establish the factual finding that a high crime area existed where Mr. Lewis was seized. The testimony was vague and the testimony was subjective. It did not define the geographic boundaries of where a high crime area existed. It did not establish temporal relevance between the crime area, the type of crime that the area was known for, and also the instant seizure. It did not establish a sufficient nexus between the type of crime the area was known for and also the police officers' observations of Mr. Lewis. It also did not provide verifiable or empirical evidence of crime data to allow a comparison between areas with regards to crime. The testimony, rather, was very general, subjective, and full of buzzwords. The Commonwealth has a burden to prove reasonable suspicion at any suppression hearing. And the reality is that if they're going to continue to use a high crime area factor as such an important part of reasonable suspicion, then it's very important that what they do is provide verifiable facts, evidence, and a good amount of specificity when it comes down to what is actually happening and what's being observed by the police officers.
What kind of facts and evidence are you talking about? When you say verifiable, what do you mean by that?
Well, for instance, the Commonwealth of Pennsylvania and also municipalities such as the city of Philadelphia have, statistics. They have arrest records. They have various records that you can find online, actually.
Mr. Alvarez, reasonable suspicion is a flexible standard. You cite United States versus Wright. Even in that case from the First Circuit, that doesn't require the prosecution to apply a multi-pronged test, as you're suggesting. So I don't think Wright supports your argument, but I'm interested as to, this is a reasonable standard. What is the difference? You want statistics to be obtained based upon an officer's arrest or his testimony thereafter, which means those statistics, your suggestion, would have to be obtained post-arrest, which makes no sense to the analysis of reasonable suspicion. Share with me. If I, as a prosecutor, had an officer and I said, "Officer, how long have you been a Philadelphia police officer? Officer, how long have you been assigned to the 12th District? Officer, while assigned to the 12th District as a Philadelphia police officer, have you ever made any arrest at 46 and Market? Officer, at 46 and Market, of the arrests you made, how many are drugs? Officer, of those drugs, how many have you arrested for possession with the intent to deliver?" And those facts are similar to the facts in this particular case. Why isn't that sufficient under the flexible standard of reasonable suspicion? Why do I expect my officer to say, "Well, lastly, at the police accountability meeting, we found out that 34% of all arrests in this," which makes no sense. So I'm trying to listen to you, but it seems that your concept or your analysis is absurd, with all due respect.
Well, with regards to the verifiable statistics, you do want statistics insofar as, in order to say that one area is high crime, it needs a comparison to another area. And because the police officers on the...
Why? Why does it have to be comparison?
Because it's overly subjective at that point.
It's based upon an officer's observation and actual contact with a particular criminal offense.
Well, in the
More importantly, isn't the entire determination subjective? Because different police officers have different experiences.
Well, it's an objective standard. We need objective facts in order to find out whether or not there is reasonable suspicion. And of course, what a police officer is thinking on the street and what they're observing and based on their experience, it is important. However, the reality is in the facts of this case, the police officers made very general remarks regarding this is a high...
Mr. Alvarez, you walk away from the mic at times, and I have
Sure.
difficulty then hearing you. If you
problem.
could try to just speak into the mic, I'd appreciate it.
Yes, Your Honor.
So I guess the question I have is, did you present this argument to the suppression court? Because I don't remember hearing this or reading this.
Well, with regards to the suppression court, no, what the argument was based on reasonable suspicion. But with regards to what a high crime area is, I mean, to put in the context, of the notes of testimony, I believe 14 pages of it was the police officer's testimony. Of that, you have the direct and you have the cross-examination, and even less than that, there's, counsel's questions, and then there was a very, very, very small portion of the notes of testimony that actually regarded high crime area. The problem is that if a high crime area is going to play such a prominent role in reasonable suspicion, then there needs to be more fleshing out with regards to an officer's experience.
Wouldn't that be, that flushing out, wouldn't that be consistent with the line of proposed questions I suggested if I were the prosecutor?
Yeah, I would go further, Your Honor, if I may.
Go ahead. How would you go further?
The reality is also you have to look at the fact that there's got to be some sort of a nexus between the observations of the police officer and what is what the area is actually known for high crime-wise.
Well, sir, let's use an example. You, me, Justice McCaffrey, we're all Philadelphians. We've all been district attorneys and or defense attorneys. I grew up in South Philadelphia. I lived at 4th and Jackson, 5th and Morris, which could be
It's a
considered...
high crime area, by the way.
5th and Jackson, 5th and Morris, which could be described as my neighborhood or not, was always known as a location you could purchase drugs. So any individual, officer would testify, historically, the arrest they made at 5th and Jackson was drugs. Now, if they made an arrest for drugs at 4th and Snyder or 4th and Jackson, does that now constitute a high crime area? The question really is based upon the observation and the objectivity of the evidence presented. So the question I have for you, what corner is not considered a high crime area in various sections of South, North, or even Northeast Philadelphia? If I'm understanding you, the use of the universal high crime area in and of itself is prejudicial and should not be considered. there has to be some additional reasonable factors brought forth by the Commonwealth in its case in chief to indicate that that officer is aware of a particular criminal act that's occurring. Is that sufficient for you, or is that still not sufficient?
Well, I mean, there needs to be temporal relevance, and there also needs to be the crime type overlap as well.
So let me break that down, because that's an important component, because you've raised really two arguments. There's got to be a temporal and a geographic kind of component to the description. I want you to talk a little bit about that, but you also have a comparative argument. If you're going to designate it as a high crime area, it's got to be compared to what? Justice Doherty just gave you an example of 4th and Jackson. It's an area known you can buy drugs. Say you have 5 or 6 police officers down there that made 5 or 6 arrests at 4th and Jackson. Would you say 4th and Jackson is comparative? I mean, would you say 4th and Jackson, based upon that police officer's knowledge, information, and belief, is justified in saying 4th and Jackson's a high crime area because he's personally made half a dozen narcotics arrests there?
I think definitely the police officer's experience does go into the
Just so you would answer my question by saying yes, you would accept that, right?
Well, there's more to it also. It's like, when did that occur?
Well, before this particular day. I've been a police officer there for a year. In the past 8 months, I've made 4 arrests at 4th and Jackson for narcotics. Would you say that justifies his opinion that it's a high crime area?
I think that gives him a lot more reason to, conduct a custodial detention.
See, this is where I'm going with the comparative argument. Would you compare 4th and Jackson to, say, 7th and Indiana, where there's probably 4 arrests before breakfast?
Well, with regards to, the type of crime, for instance, I think, if I'm understanding your question right, I understand that there's...
No, I'm asking you the question. The question is, how do you compare them to neighborhoods?
Well, statistics, evidence, crime.
But isn't that evidence, even though it's not comparative? If we have a high Kensington's a renowned, I mean, literally nationwide area for drug violence and a lot of other crimes. You can't compare Kensington to any other section of the city of Philadelphia in terms of drug arrests, but you're asking us to kind of impose some type of comparative standard on an officer's observations regarding a designation of a high crime area. So I'm wondering, I'm asking you, how does that work?
Well, I guess the point is this, is that if a police officer's individual experience is a certain area or a police service area within a district, that does limit their perspective as to crime in other areas of the city. And I do proffer that it's important to know the entire scope of crime in different parts of the city as well.
How does one police officer know that? If I'm a police officer assigned to the 22nd District in North Philadelphia for my entire 5 or 6 year career, how do I know what type of crime and how often crimes are reported in Chestnut Hill or far northeast for a comparative analysis, as you're suggesting?
The Commonwealth of Pennsylvania and also the city of Philadelphia, they do track statistics, and they do have this, and there's actually websites for it. But the police officers at a suppression hearing should be tasked, or rather the Commonwealth should be tasked in having their police officers testify to actual...
But isn't it about what they knew at the time, counsel?
Correct.
What are they supposed to go do research later to prepare for the suppression hearing? I have no idea what your argument is. I don't know why you didn't argue for abolition of this criterion. You didn't. You waived that. And so you're kind of sort of telling us that officers should prepare for a suppression hearing by going and doing research about, and that's not at the time of the stop then, so that's irrelevant. So you expect officers on the beat to be aware of ever-evolving crime statistics and then without defining how much crime is enough crime? I mean, are we sitting in a high crime area right here? This is a morass, and I don't understand why you want to, as the defendant's lawyer here, as the appellant, why you want to swim in this quicksand rather than making an argument you failed to make about abolishing this unmanageable standard that treats different neighborhoods differently according to their income level?
If I
or
may.
crime?
Certainly, well, the reason it wasn't raised on appeal is that during the suppression motion, the constitutionality of the high crime area wasn't raised. So at the appeal level, it was also not raised because it wasn't preserved. And then that's why we're here. So really, this is a sufficiency of the evidence. And I hear what you're saying, and I don't disagree with it. I guess the reality is at the time when the motion to suppress was litigated, it was simply not one of the grounds at the suppression hearing, so it wasn't preserved. And
So we don't have a constitutional question before us.
There's no constitutional question. This is the sufficiency of the evidence.
That's an honest answer,
Right.
which always wins you points. I guess I have a question on whether this is even the case to talk about unprovoked flight in an alleged high crime area. If I understand what the Superior Court wrote, what the trial court wrote, and I don't have the reproduced record in front of me, but that these officers just didn't stop at a random block. These officers witnessed what they believed to be gambling, and that's why they stopped. And then one officer made eye contact with the defendant, and the defendant fled. So does the high crime area issue even matter here? If law enforcement saw what they believed to be illegal activity, they could engage in a Terry stop at that point in time, couldn't they?
If it was Mr. Lewis that was engaged in what they believed to be gambling.
Well, he was in a group of people, and they witnessed a group of what they believed could have been gambling. They don't have to be right, but he was in a group of people. I mean, we have another case that we're looking at involving nothing other than the fact it was they rolled up and people ran. But this case is different. They saw what they believed to be illegal activity in a group of people. It usually takes a group of people to gamble. Did they necessarily see your client with money in his hands or something like that? No, but he was in the group. They stopped, and he ran. Why isn't that Terry?
They admitted they didn't see him gambling, correct? It's not illegal to watch somebody else gamble.
Correct. He was merely present, Your
Correct.
Honor. And because he was merely present, it didn't give the police cause to seize him.
And this was all about flight in a high crime area. That was their reasonable suspicion, correct?
Correct.
Period.
Well-
He ran in a high crime area because they did not see him gambling.
Correct.
Right. But I guess my question is, I'm not sure that I agree that that's necessarily the standard. If you have a group of people gathered, that and the group is engaging in what appears to be gambling or may be engaging, you don't have to be right. The idea that group may not be enough, that you actually have to see one of them at that moment in time in that iteration throw the die or pick up the. I mean, I'm not sure I agree with my colleagues that that's necessary, but at least that was why they stopped. They didn't stop because it was a high crime area. They stopped because they were witnessing what they thought was illegal activity.
Right, but once again, I do draw Your Honor to the record, and Mr. Lewis quite simply and quite candidly was just standing there. And that's his constitutional right to do so, is to be let alone.
Well, are we to take into consideration that this is Philadelphia, which is a city of neighborhoods, which means you could walk on every street and see large amounts of people hanging out on the corner for which they have great respect, saying, I am the 2nd Street, or I'm 12th and Diamond. And that if you're observing a basketball game, they may be betting on the basketball game, they might be watching somebody play dice. That's not sufficient probable cause. And considering the concern of disproportionate arrest, might cause one to pause if they see a police officer pull up, stare at them. They might choose to run, as I did as a child when I used to see the cops doing nothing wrong, but you knew you may get arrested. So the question becomes, it's not necessarily the fact that he was standing watching what he believed to be, or what is alleged to have been gambling, it's that the use of the term high crime area insinuates that he is participating in crime based upon the pure location of the quote-unquote high crime area. There would have to be additional evidence that there had been arrests made in and around that area for gambling that would support a reasonable suspicion that an individual standing around or stooping down looking at dice or holding money, that's reasonable suspicion. But otherwise, based upon certain concepts, anytime you stand on a corner in the city of Philadelphia, that could be reasonable suspicion for police intrusion. I'm not buying that one.
And with regards to the facts of this case, and, you know, Mr. Lewis is requesting a reversal of the conviction and a vacating of the sentence because if it wasn't for the categorization of that area being high crime, he would never have been chased.
Well, let me, I don't want to make your argument for you, but I'm going to help you out here. My understanding or my recollection of the record was that the police officers described it as a high crime area. There was no real follow-up with regard to what basis they had for describing it as a high crime area. In fact, I think one of the officers was asked, why did you say that? And he says, well, after this particular incident, I've made several other arrests. Doesn't there have to be a temporal argument to the designation, which is exactly what I was trying to get at earlier, for the high crime area? In other words, I can't say I made an arrest at 12th and Diamond. 12th, this was 12th and Dolphin, right?
Yes.
So I made an arrest at 12th and Dolphin, and they asked me, it's a high crime area. Well, why did you say that? Because I've made 5 arrests after this arrest. That doesn't mean it was a high crime area at the time I made this arrest. You have to temporarily say, yeah, I know it's a high crime area because there was 40 shootings at that block or within the next block within the month before that. So isn't your argument in this particular case that the testimony that was on the record from the police officer that justified his opinion of a high crime area happened after the incident in question?
You're referencing the carjackings that were testified to?
No, I'm referencing the officers. Yeah, exactly.
Right. I think, I definitely do not think that that goes into the totality of the circumstances analysis. But with regards to what was testified to, that both officers said that they had experience was the high crime, and it's a lot of gambling, it's high narcotics, that sort of thing. And that was all suggestive and did not have teeth to it, which is why the sufficiency issue is that there was not enough evidence through the testimony of the police officers, because it really was buzzwords and talismanic phrases, and that's why
Counsel, Justice McCaffrey hit your argument on the head, which actually I thought you made in your brief also. I mean, the reason this is insufficient to establish a high crime area is the only evidence of crime at all was 4 or 5 carjackings after this arrest, and no evidence of there ever being a gambling arrest in the entire experience of the officer who was involved in this incident. And so the question is that sufficient to establish a high crime area?
No, it is not.
Okay, well, that's what I thought your argument was, but.
Well, the testimony from the suppression hearing says the officer testified, due to the area's known gambling area, a known narcotic area, and the manner they were standing, just from my experience, they appeared to be gambling. And then later on, they testify, in the area of 2200 of Dauphin, that area is known for narcotic sales, gambling goes on that area. So.
Do you want to respond to that?
I don't know, that was a question. I was just clarifying.
Question mark.
Question mark.
Right. Then again, there's not, the temporal relevance isn't really there. There's no specificity as to when it happened, how many times it occurred, and then also.
Well, wasn't that your job as the defense counsel to cross-examine the officer if you didn't think it was a high crime area?
Well, I wasn't the defense attorney at the time, but I think that the cross-examination with regards to defense counsel was adequate, quite frankly, because it highlighted the fact that there was no actual evidence presented through the testimony. They really were general. I know that there was no constitutional argument made at that stage, but the reality is that sufficiently, the Commonwealth did not make its case.
Well, I just read two.
I'm not sure. I'm sorry. Go ahead.
I just read 2 portions of the suppression hearing transcript where the officer testified that that area is known for gambling, that area is known for narcotics. both of which are a crime. I did not see anything, and maybe I missed it, and I apologize if I did, but I didn't see anything in this transcript where the defense attorney said, how many arrests have you had in this area for narcotics? How many arrests did you have in this area for gambling? Can you please define the area that you're describing as a high crime area? I didn't see any testimony or questioning to cross-examine the officer about the issue you're now raising before the court.
You make good points. I would say that it did come out on cross-examination, however, that no citations or arrests were made with regards to the gambling, and that neither officer could testify as to that. And neither officer was exceptionally experienced. I think one was probably less than a year on the job at the time, and the other was definitely less than 3 years on the job. But I would also point out the fact that, you know, as far as the type of crime, there's got to be some sort of a nexus between the type of crime in the neighborhood that the neighborhood is known for, and then also the alleged observations by the alleged, you know, criminal acts that are in process.
Why do you suggest that again? Because you're losing me there again. Because you're arguing to us that we need to kind of write some opinion that establishes a nexus between the type of crime that area is known for. If 12th and Dolphin had 15 carjackings, does that mean an officer couldn't make a narcotics arrest?
Not at all. I think common sense-wise, I see exactly what you're saying. I think what I'm trying to say is that as far as a high crime area designation, and it was in one of the journals, and it's kind of a modification of it. If an area is known, for instance, as a high crime prostitution area, that's a crime that's committed behind closed doors, that does not give law enforcement the reasonable suspicion if they're observing what they believe to be drug transactions.
Why should have made a constitutional argument? I mean, I just don't understand why defense is making all these concessions about the validity of this label that designates every human being in any area of this city as having less constitutional rights than people in other neighborhoods.
Well,
but you don't have that argument, so that's fine.
It
So
wasn't.
we're left to try to argue about what's sufficiently objective, and it's sort of as I said, it's quicksand in my judgment to even delve into this because it's so elastic and inherently subjective.
It wasn't raised at the suppression hearing. It was not one of those things. It wasn't raised on direct appeal with Superior Court. So we briefed,
Well, what
with
if
regards to the sufficiency aspect.
I mean, your answer is simple. It's not preserved, and you're arguing what you can argue, and we took it. I mean, that's kind of where we are. But I wonder whether we should hold this, because we do have another case that we're going to hear squarely on the constitutionality of it being a factor.
Yeah, I'm aware of that case, Your Honor, and if I may, I'm not disagreeing with Justice Weck and or what you're.
Because it may moot your case. If we say in Shivers, high crime out the window, and I'm incorrect that they had some other reason to at least engage in a Terry or
That would be a
something.
gift, since we have no argument on it, it wasn't preserved, and there's no Edmunds analysis. I mean, I guess we could hold it.
Yeah, but I'm one cog in a 7-cog machine, so I don't know. We'll see what happens.
All right, do you have anything else you'd like to share with us, Mr. Alvarez?
Yeah, I was going to ask, address the forced abandonment issue.
Forced abandonment, our argument's very simple. There was not a high crime area established sufficiently evidence-wise, and as a result, the unprovoked flight was the seizure was unconstitutional, and at that point, when he did throw the gun, it was something that should have been suppressed. It's a forced abandonment, essentially. I think the first issue that was presented by the court directly dictates the second one.
Correct. Okay.
Any other questions? Okay, thank you very much. Let's hear from Mr. Wildberger.
Good afternoon, Your Honors. May it please the Court, Stephen Wildberger on behalf of the Commonwealth. Your Honors, I know it's been a long day. I'm the very last person to make argument today, so I'll try to be brief. I very quickly, before delving too deeply into my argument, I do want to try to address some of the questions that the Court had for my opposing counsel. Justice Brobson, I want to start with your observation of the facts. And to that, I'd say you're absolutely correct. The reason that the officers were approaching the defendant in the first place is because they believed him to be engaged in gambling. And you're also legally correct that it does not have to be that the defendant is acting alone or that the defendant has to be holding cards. That's actually what Terry tells us, right? The Terry opinion was multiple defendants engaging in what appeared to be sort of collective suspicious behavior. There didn't have to be one individual.
Well, Terry, they were casing a place, and based upon the police officer's training, education, and experience, he thought they might be armed and dangerous, which justified a pat of his outside clothing. This isn't a Terry stop.
Correct, Your Honor. It's not a Terry stop. My point being that Terry recognizes, and a slew of other cases recognize, that collective action can be suspicious as well. So the officers here testified that in their experience, it appeared that the defendant and 4 or 5 other men were engaged in
So it's an investigatory stop. They went up to see what the guys were doing. The guy takes off and runs in a high crime area, throws a gun. That's where we are, right?
I think that's generally true, Your Honor. When the officers approach, it's a mere encounter, and then when he then makes direct eye contact with Officer Brush, I believe was his name, makes sort of an acknowledgement that this is a police officer, who's a uniformed officer exiting a marked police vehicle.
Never
and then
make eye contact.
I'm sorry, Your
Never
Honor?
make eye contact.
That's the key, Your Honor.
Counsel, you're saying that you concede that the police officers did not have reasonable suspicion until he fled?
No, Your Honor. The Superior Court characterized the approach by the officer to the men prior to the flight as being a mere encounter, and defendant hasn't challenged that, so I'm simply adopting the Superior Court's
Okay, but you're saying the mere encounter with, okay, maybe I just have to go back and look at this again, which is probably true, but when law enforcement sees what they believe to be illegal activity among a group of individuals, and they walk up to them, you're saying they don't have that's not reasonable suspicion?
No, Your Honor, that's not what I'm saying. Certainly, police may have had a reasonable suspicion at that point, but they hadn't seized the defendant at that point.
Yes, see, they hadn't, but let's just be clear on the record. I thought the suppression record did not indicate that the reasonable suspicion was from percipient observation of gambling. They saw men congregating on a corner in an area that the officer testified was one that had gambling. Is that right?
Your Honor, I believe under the totality of the circumstances test, all of those factors are relevant to the reasonable suspicion analysis.
Am I right about what I just said? Did they see this guy rolling dice, for example?
They saw what they believed to be the defendant engaged in gambling with a group of other men.
That's what the Superior Court said. The Superior Court said they appeared to be gambling.
And that's what the suppression record supports as well. That's a supported finding by the trial court that the Superior Court
So I just want to be clear, was there reasonable, then is it your argument that there was reasonable suspicion without the flight? If they were gambling and he believed it was illegal gambling, there's reasonable suspicion. Boom, right?
I don't think it's necessary to reach that question, Your Honor.
I'm
sorry.
I'm trying to get at what your argument is. Is it that the flight, is it men congregating in an area that later an officer will say is a high crime area, and then the fact that he runs, is that what gives the reasonable suspicion? What's the law here that you're arguing?
So the reasonable suspicion is a totality of the circumstances test, right? So all of that is relevant. The fact that the officers observed the defendant in what appeared to be gambling, right? They reasonably believed that he was engaging in gambling, which is illegal in the city of Philadelphia.
Can I stop you there for a moment, because that is not what the record reflects. Record reflects that the officers admitted that they did not see the defendant gambling.
I apologize, Your Honor. I respectfully have to disagree. The record demonstrates that the officer, I believe it's Officer Watley, says that I saw what I believe to be defendant engaged with 4 or 5 other men engaged in gambling. Now, the defendant did not have dice in his hands. He didn't have cards in his hands. He didn't have money in his hands. That's all true. But the Officer Watley testified that he saw what he believed to be defendant engaged in gambling with 4 or 5 adults.
By his mere presence, watching.
That's what he understood, that the defendant was engaged in the process of gambling.
Because they saw him standing watching other people with dice in their hand, rolling money, and participating.
He was in close proximity with those men.
Correct. Okay. So are you conceding?
I'm not conceding anything
so
to my knowledge, Your Honor. Not intentionally.
So did you share with us that the initial encounter was a mere encounter?
The Superior Court found that when Officer Brush exited the vehicle, it was a mere encounter until the point that the defendant fled, and that's when it became an investigative detention.
So the individual's flight from an officer approaching him, you're saying is sufficient to raise the level to reasonable suspicion, despite case law that says you don't have to answer a competent mirrored inquiry?
There's 3 factors here, at least 3 factors, that provided reasonable suspicion to the officers. One was that the officers observed what they believed to be defendant engaged in gambling with several other men. We've discussed the contours of that. The second is that this occurred in a high crime area, as Officers Watley and Brush both testified, and the defendant fled unprovoked after acknowledging that this was a police officer, at least implicitly, by making direct eye contact. His eyes widened in what appeared to be acknowledgement.
So Officer Watley testified on that first thing. He testified that he did not recall observing anything in Mr. Lewis's hands. He testified to that at suppression.
That's
so the statement now that he was engaged in gambling, I'm not sure you're there. It seems that the high crime area then designation is doing the work for something that was, we might say was very good hunching. I mean, these are experienced police officers. They have instincts, they have hunches, they have experiences. But, you know, we do have a constitution. I know that argument's not here.
Yes, Your Honor.
And I just, you know, when we say his eyes grew wide, so then the implication would be if his eyes did not grow wide, maybe there's not reasonable suspicion. Or if he walked away instead of jogged away, maybe there wasn't reasonable suspicion. It just illustrates the slipperiness of this whole doctrine. Again, I recognize that for whatever reason the defendant didn't bring this here, but it's highly unsatisfactory, and then you're left to argue, well, maybe we should apprise police officers of what the statistics are, or I mean, how do we define? Let me ask you this. I'm waxing on. Let me ask you this. Is it troubling to you as an assistant district attorney here that basically what we're doing is effectively branding residents of some parts of your city as inherently more suspicious than others, just because we might say they live in a high crime area? Does that trouble you?
Your Honor, I am personally speaking as an assistant district attorney, I am sensitive to the issue. I have read a lot of the case law, both cited and uncited. I read a lot of the scholarly articles, and I'm sensitive to that issue. I'm also sensitive to the countervailing issue, and this is one that the Attorney General's office raises in its brief, and this is pages 13 to 14. And they recognize that the counter to your point is true, and that is that real people live in those areas that are high in crime, and they deserve to have vigorous policing as well to protect them. And so, you know, the brief says, you know, to require police to disregard facts which as a practical matter are highly relevant would do violence to the underlying purpose of the Fourth Amendment and would in fact do a disservice to the honest citizens residing in a high crime area. And that's from the Lefebvre Treatise to Search and Seizure. And so, Your Honor, I am sensitive to your concern. I think it is multifaceted, and I think it's a difficult question.
Commonwealth,
Yes,
share
sir.
with us what type of evidence do you believe is sufficient to establish a high crime area?
I'm again going to point to the Attorney General's brief. And the Attorney General's brief, I think, does a very good job of laying out what I think, workable solution, so to speak, would be, right? And it's a matter of weight to be given to the evidence. So to step back, Your Honor, we can't put guardrails on the totality of the circumstances test. Innumerable U.S. Supreme Court cases have said, innumerable, we could put a number on them. Many U.S. Supreme Court cases have said that. I was prepared to quote for you from Florida versus Harris. I don't think it's necessary. So I think having strict guardrails is not workable, but the point being that the fact finder should be encouraged to and trusted to weigh the Commonwealth's evidence and determine how much weight to give to the high crime factor, if at all.
So, Commonwealth, if the evidence was brought forth by your prosecutor to the officer that he had been an officer working in that district on that day and time, and he observed what he believed to be gambling, and subsequently he says, I believe this to be a high crime area, is that sufficient?
Simply intoning the words high crime area, I do not believe would be sufficient, Your Honor.
If he said, I believe it's a high crime area because I made subsequent arrests, is that sufficient?
I think that depends on the temporal relationship. I think that this is something that is a weighing factor for the court, right? The further out in time, the temporal relationship, either before or after, if it's relevant. And let me back up, Your Honor. I should say the testimony about the arrest would be more relevant and perhaps only relevant if about before this particular arrest.
Assuming that this arrest was before the officer's testimony that it's a high crime area because he made subsequent arrests, is that sufficient?
I think that would depend on the rest of his testimony, whether there's evidence that the area was high in crime prior to the arrest in question as well.
But that's not the question I posed. The question I posed is there is no evidence. It's the officer claims it's a high crime area because subsequent to the initial arrest for which he's testifying, he made subsequent arrests. Is that sufficient to establish reasonable suspicion in the courtroom on that day as opposed to the actual day of the arrest?
If the only evidence about the area being high in crime relates to criminality after the arrest in question, I don't see how that could be.
Counsel, is that not the record here?
Your Honor, that is respectfully.
Can you repeat?
Respectfully, that is not the record here, Your Honor. Justice Mundy read us.
The record here states that he indicated that this is an area known for gambling, correct? And he never made any arrests for gambling. And there's no evidence in the record that there were ever before or after arrests for gambling in the area. So what we're dealing with is 4 or 5 carjackings, of which this defendant was not suspected of doing. And even so, those 4 or 5 carjackings were after his arrest.
Respectfully, Your Honor, I have to disagree, and I disagree on 2 principal bases.
Okay, what are
the
they?
first being that part of the testimony included testimony about narcotics. Now, again, I know that wasn't tremendously specific.
But he's not suspected of engaging in narcotics use or trafficking or anything. He's suspected of gambling.
So let's focus specifically on the gambling.
Okay.
Right? If the statement is that we can only credit that testimony if that officer has made particular arrests in that area and then he has to testify to the volume of arrests that he's made, what we've done is we have endorsed the statistical analysis that the defendant is suggesting. And the statistical analysis is problematic because it is both over and under inclusive.
I'm not talking about any kind of statistical analysis. I mean, I'm just talking about the record here. It's known for gambling. The area is known for gambling. He didn't make any arrests for gambling, and he apparently doesn't know of any other arrests for gambling because when he knew of arrests for carjackings, he testified about those carjackings. So there's no evidence of arrests for gambling.
That's sort of part of my point, Your Honor, is that arrests for gambling doesn't prove whether gambling occurs. And If I may, that's part of the problem with the statistics.
And it's part of the
It's
problem
under-inclusive.
with this
I'm sorry, Your Honor.
whole rabbit hole that we insist on going down here, because all of these arguments become ex post facto make-weights to go back and jerry-rig, to go back and say that back then there was reasonable suspicion, when in fact these are non-individualized. The whole basis in our jurisprudence is that there has to be particularized suspicion about this individual, as opposed to judgments about what the neighborhood is like, or things of that nature, which are really cloaking a hunch, which may be a really great hunch. It's just not what our Constitution says we're supposed to do.
Justice Wecht, acknowledging that the constitutionality issue is not before the court today, I'm happy to engage in some, sort of academic conversation, so to speak, about this if we can. I would respond to you about the individualized issue, and I would respond to you with your own words from the Hicks opinion, and that is that you described high crime area as being a relevant contextual consideration. And it is a relevant contextual consideration.
I was young.
Unfortunately, the Supreme Court of the United States has said the same thing, correct?
It is a relevant.
And there you go.
They have not evolved.
And there you go.
Yeah.
And
Yes.
we have, and we don't have a constitutional issue. We have a sufficiency of the evidence issue here. What about this evidence makes it sufficient to support the conclusion that this was a high crime area?
As the law exists, and I outlined this is sort of the first thing I did in my brief because I sort of expected it to go this way. And the issue of whether an area is high in crime is a factual finding, and the trial court here credited the officer's testimony, which was not contested in cross-examination as demonstrated and discussed by Justice Mundy, and the court credited that testimony, and that creditable testimony supported its factual finding such that this court owes that factual finding deference.
A Commonwealth, you claim a temporal consideration is essential to your analysis? Yes or no?
No, Your Honor. I believe that can be relevant to the strength or weakness of the evidence, right? That's an issue for the court to weigh.
So, on page 11 and 12 of the notes of testimony, the court begins by asking an officer, can you say that this was a high gambling area? Can you tell me anything else about this block in the immediate vicinity? Answer, in the area 2200 block at Dolphin, the area is known for narcotics, gambling goes on in that area, and in the relatively recent past, there's been a lot of carjacking in that area. Question, an officer, how long have you been in been with the force? Just 3 years now. And have you been in the 22nd district all that time? Just about yes. And have you worked on this particular block? Yes. Yes. I'm assigned to that sector almost daily basis. Have you observed individual gambling before? Yes, very frequently. Approximately how many encounters have you had with people gambling on the street or ballpark? A lot. It's very common in that area. And officer, as you just go back a bit, did they begin fleeing once you exit your vehicle while you're in the vehicle slowing down? I don't remember. So share with us, is that sufficient? That testimony that there's no specificity, there's no particularity as required by the Commonwealth pursuant to the local rules to articulate with specificity and particularity the basis for the motion and the grounds for which you base. Is that sufficient with a generalized, blanketed, yes, the 22nd is a high crime area because there have been many encounters with people gambling on the streets?
That testimony credited by the fact finder and not countered by adequate cross-examination is sufficient, Your Honor. Yes.
Okay, I think we understand. Is there any other question that someone wants to proffer to the council? Thank you very much. Well argued.
Thank you, Your Honor.
I believe that concludes our argument session for today, Mr. Minner.